Date may not be fixed. Next week, Lordship.
In the next week.
Lordship. Lordship.
Date. Not be fixed. Yes.
Yes, Lordship. First, I filed a petition, SI 24, transfer of the suit filed by my husband. I am the petitioner wife. Lordship. Sir, our marriage by staying some days, I have to leave the place of my husband. Thereafter coming Guwahati Lordship, right, I have filed one proceeding under section 125.
In Guwahati. In Guwahati.
Yes, Lordship. I'm in Guwahati and my
Whether husband is appearing in that 125?
all cases he is appearing here, Lordship.
How many cases are
Four
there?
cases are there, 125, then the V case and 1406, all cases he is appearing and his salary still I have enclosed, he is drawing salary of 72,000. Until that, I have not get any amount, Lordship, any maintenance. And Lordship, I have lots of.
Heard Mr. Day, learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure, 1908 has been filed by the petitioner Srimati Sonali Das, praying for transfer of title suit within bracket M number 26/2024 filed by the respondent against her, seeking dissolution of the marriage by a decree of divorce from the court of learned District Judge Vishwanath Chareli to the court of learned Principal Judge, to the Family Court, Kamrup Metro and Guwahati. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 6th of September 2024. At what stage?
Now, 16:8 is the stage I have to appear and file my WS Lordship. So 16:8.
Okay.
So, may I place a matter will stay till returnable date, Lordship?
In the meanwhile, stop. However, in the meanwhile, the further proceeding of title suit notes. Before this, learned counsel for the petitioner has submitted that in the meanwhile, the petitioner has already filed a maintenance case under section 125 of the CRPC and
And the DV case, Lordship.
and also a DV case.
Uh,
How many other cases?
Many other cases, 4 cases.
4 cases.
Yes, in all
And
cases. he appeared.
3 other cases
And cases
against the respondent and those cases are filed in the Kamrup Metro District, and it is also submitted that the respondent is appearing in
all the.
all the cases. So, in view of above, further proceeding of title suit within bracket M number 26/2024 shall remain suspended till further order.
Yes, please, your Lordship. My lord, here in this case, I have filed amendment application that was rejected. Amendment which has been sought for, my lord, virtually it is a correction. Kindly see page 10. It is the plain. We sought section 13 of the Hindu Marriage Act. It should be Special Marriage Act, 27 of the Special Marriage Act. And 19, page 19 in the prayer portion. These two correction I have filed application that was rejected on the ground that
At what stage you have filed?
It is evidence of the defendant side. But I have,
Your prayer was contested by the other side.
it was not, they have also specifically stated.
No,
that it
no,
is-
your order 6 rule 17 application.
Yes.
Which you have filed before the
That
trial
was-
court, whether it was opposed by the other side,
Opposed, kindly see the objection file. there.
whether it was opposed or not,
Yes, it was opposed.
and we are issuing notice.
My lord, only, basically only correction I have sought for,
No,
nothing else.
if it was opposed, then we have to hear.
Yes, kindly see page 36.
No, we are issuing notice. Heard. Mr. S.K. Ghosh, learned counsel for the petitioner. All this application under Article 227 of the Constitution of India has been filed by the petitioner Kingshuk Adhikari, impugning the order dated 12/7/2024, passed by learned Principal Judge Family Court Kachar at Silchar in FC within bracket civil case number 88/2018, whereby an application filed by the present petitioner under Order 6 Rule 17 of the CPC for amendment of the cause title of the plaint filed in the said case was rejected. Stop. Issue notice to the respondents. The petitioner shall take steps for issuance of notice to the respondents, to the sole respondent by registered post with AD, as well as by usual mode, within 3 days from the date of this order, returnable on 6th of September 2024.
But, till then, my lord, for proceeding.
It is your proceeding. You have filed divorce.
Yes.
Okay. Till then, till the returnable
Yes.
date, the further proceeding of who has filed this? You filed that divorce case.
I have filed that.
The further proceeding of FC within civil case number 88/2018 shall be kept in abeyance. Shall remain stayed
Till next.
till next day. Stop. List accordingly.
Okay.
I'll get there below, entire file দিব ইয়াত।
May it please discuss.
Yes.
Well, this revision is under section 115 of the CPC, my lord. And urban areas rent control, like challenging the judgment on decree dated, my lord, passed by the learned court of civil judgment. On both grounds, my lord, on point of defaulter as well as on bona fide requirement,
It is against judgment of the appellate court.
appellate court.
So whether the case is admitted,
Case is not admitted.
we'll admit it.
Lordship, kindly peruse order dated
Records have already.
21/12/2020.
Records are there or no?
Records are there.
Records are there.
Records are there. Kindly peruse order dated 21/12/2021.
21/12.
2021.
There is no order.
So
Order is
was
on,
decided to dispose of the matter at admission stage itself, being case under urban area rank control act. And lordship, thereafter, the matter was heard in detail, both sides on 11/1/2022. In fact, after hearing the matter, court also supposed to pass judgment. But at the time of passing judgment, it came to the knowledge of the court that once upon a time during practice time, my client was represented
okay.
by him in
No,
another case.
that means
That is why
It
That-
was heard earlier,
Heard
was
earlier,
heard, my
it
lord,
was
but-
also asked.
but
not
still
at
it
that
is in
time.
admission stage.
Yes.
It was not.
How much
before
time
that.
is required to him for peaceful vacation? That was also asked.
You are
by the-
tenant.
I am
Yes,
the
con-
tenant.
Concurrent finding is there, Lordship. So defaulter parties, there is sufficient materials if
It
you.
will take some time, my lord. Today is a motion day, my lord. It will-
No,
No,
it
that
will
is-
not take time. I will take only 10 minutes time, Lordship.
No, let us admit it and fix it on a fixed date.
My lord, may do.
We can do that,
Suit is filed in the year 2013
yes.
and appeal is filed in the year
My lord, may fix it,
2016.
man. I'll do
It
it on
is-
that day.
It is.
You are
about 11
interested
years.
to,
I'm the unfortunate tenant, my lord.
therefore you are not interested to hear the matter.
I'm interested. my lord.
In hearing.
Sufficient material, concurrent finding with respect to defaulter.
But my lord,
per
interestingly,
their
I'll just
own
point out
document.
one thing, my lord. I'll just point out one thing. It was the trial court, my lord, on the ground of defaulter as well as on bona fide requirement
No,
passed a judgment.
we have to decide whether we will hear it now or you are ready or not.
I'm ready, otherwise.
Then let us hear it.
Yes.
Okay. Just a minute. Yes,
My lord, the tenanted premises is measuring about 133 square feet, my lord, from where I'm running my business of selling suitcases and school bags, my lord. Messrs.
just
A,
a minute, just a minute. Or we will, let us admit it and fix it tomorrow on a hearing day.
Yes, Lord.
Ins-
That can be done.
Otherwise it will,
Yes, Lord.
we don't know how much it,
Yes, Lord.
we'll admit it
Tomorrow.
and fix it tomorrow.
Tomorrow, Lord.
can it be on Tuesday, my lord? I have a fixed matter,
Okay,
Tuesday.
Tuesday on a hearing day.
my lord. Tuesday.
Normally, matter will not take so much time, Lordship.
No,
It is.
I have a fixed matter, my that's why. Let it be on Tuesday, my lord.
heard. Mr.
Iqbal.
A. Iqbal, learned counsel for the petitioner, also heard Mr. R. Ali, learned counsel for the respondent. This case is admitted for hearing, considering the long pendency of this case, as well as the fact that the original decree was passed in the year
16.
2016. Let this matter be listed for hearing on 6th of August, on Tuesday, on 6th of August.
Item number 4.
Obliged.
On last occasion, your lordship had raised the matter at some length with regard to dismissal of our execution petition for dismiss for default. And 84 page was the operative portion of the important order.
Whether notices were served,
What matter? They have appeared
Okay,
over
okay,
3 dates
okay,
opposite
okay.
side.
yes.
On last date also they have not appeared.
What is your submission? What is your submission?
My submission is that
What,
your lordship make some.
is there any
queries.
period of limitation in this case?
No, madam. There is no limit.
What was the decree?
Decree was for handover of possession of the shootland, 1/5 lectures, which was the belongs to the present petitioners.
Then limitation is there.
Limitation-
When the decree was passed,
Decree was passed on 26/8/15. In PS number 4 of 2010. 26/8/15. Execution was filed on 27/4/16 after a period of 6 months.
Thereafter,
Thereafter, my lord, the proceeding continued and there was also an order was passed by the learned Munsif for delivery of possession by paying necessary costs. And
in the execution proceeding,
yes, yes, while when it was pending before the court of learned Munsif Rongia, but unfortunately, it was due to amalgamation of districts. At that point of time, some cases were transferred to Buxar district. So as a part, the matter was against commenced in fresh as per proceeding. So as a part of proceeding, on one particular date,
period of go. There is a limitation also for under Article 136 of the Limitation Act, 12 years.
yes, 12 years is the finalization of execution of decree. But we have filed this execution within a period of 6 months of passing of the decree. Because in the meantime,
Now, is there any, no, then what happened?
thereafter, my lord, first court has was not inclined to accept our prayer that the decree holder number 1 was ill and accompanied by some other petitioners also. Those are brothers to hospital. Thereafter, we have filed a Miss J case in appeal before the learned civil judge.
Under what provision?
Provision was already, your lordship has find out on last occasion, 106, read with 151 CPC.
Okay, when it was dismissed,
It was
where is the dismissal order?
Lordship may come to annexure 84 onwards, the operative
Page
person.
number
84.
84.
First dismissal was so 70 onwards, annexure 7 may kindly be perished.
No, no. When it was dismissed, date of dismissal, which
Dismissal.
by which order the
On
execution case,
9519.
where is the, which page?
Lordship, page 70.
No, 70 is the order passed by the court
Oh,
on,
sorry, 65.
where is the dismissal
Lordship,
order?
annexure 5, 65.
65.
65.
This was dismissed
For default.
for default.
Thereafter, we have filed.
Now, what is your submission? Whether
My submission is the.
can it be dismissed for default? First query. Then query
It
is
can be,
if it
can be, but it can be.
under what provision it can be restored?
It can be restored. As per order, Joe here is quoted my learned friend in the court below, filed under order 21 rules 1061 of CPC, read with 151 CPC for restoration of TX case number so and so. But actually, with regard to dismissal of any petition for default, order 9 rule 9 is the appropriate suitable provision, so far as I have gone through. But the same is not quoted. There was a wrong provision quoted, it is admitted. But though wrong provision primarily it was quoted, but 151 is there. 151 can be invoked at any stage of proceeding for to cause substantial justice to the litigants. And there to that effect, I have also some judgments.
No, is there any bar in filing a fresh execution petition? There is no bar. You
No
file a fresh execution petition because
But
there
then
is no
that-
provision for restoration.
Oh, that was a part of procedure. Similarly, normally all the.
On
advocates-
last occasion, I requested you to show me an authority on restoration of execution
Yeah.
proceeding. Have you brought any?
Yes. Under section 151 CPC, I will produce, just your lordship is making query, contribute, that's why I have not relied, I will rely before lordship.
Okay, tell me.
Now, I am just going to the facts now. Up to facts, what happened? By quoting a wrong provision, there is also read 151 CPC is there. If your lordship would go through annexure 6, page 66. Next page. At the bottom of this page.
Which page?
Page 66, next page. Annex C. 66. This was the petition for restoration. At the
No, no.
bottom, a petition.
When
for-
when there is no bar in filing fresh
Normally, my lord,
fresh
no
execution.
person- No person approaches the honorable courts for the, to file a fresh suit on same cause of action which has been dismissed for default. There is
No,
a
no.
possibility of.
Question of
res-
suit is different.
res
Question of
judicata may come.
execute, in execution petition, question of res judicata is not,
Doesn't come.
doesn't come.
It's fair.
So if there is no bar in filing fresh execution petition,
may
you
be-
can still file.
That may be not as per the wisdom of my learned friend of the courts.
I'm passing order, you file and fresh, if
No,
it
man.
is within the
That-
period of limitation.
Yes, just Lordship may gone through, there is no necessary to file the fresh execution because Lordship may interfere with these orders. To what, for why your Lordship can interfere, I will show the reliances of this Supreme Court also. Because if the proceeding is freshly initiated, then it will cause some more time and it may some difficulty for the decree holders also regarding some lenient techniques of the opposite sides and other court procedures.
In order 21, restoration provision is under 106. If the application is made
It's not
under
here.
105,
Yes,
that if
Yeah.
an application is dismissed for default, which
yes,
is fixed for hearing,
hearing.
then 106
Your Lordship have
may
gone
be
through on
taken,
that. Yes.
resorted to.
But here in this case, there was no space provision in this court to, what would be the appropriate provision, what is the appropriate remedy if the suit for, is dismissed for default
Not suit, if the execution
execution.
case is dismissed for default.
Yeah, there is no express provision, which we have also, drawn Lordship's notice on last occasion. Next, my lord, though against this, we have preferred a misjudge. In this case, by Annexure 7, Lordship will find at page 70. The learned executing court was not inclined to accept our prayer, and it was accordingly dismissed on the grounds which was not appropriate as per the order of the learned executive court. Then we have approached the learned civil judge against it, but learned civil judge invoked some different technical matter while dealing our appeal, miscase appeal, wherein it was observed that we have quoted some wrong provision. Now, my lord, wrong provision as per Honorable Supreme Court judgment, merely quoting a wrong provision deviated from substantial issue is not permissible. So, to that effect, I would like to produce. There are 9 million.
Yes,
In paragraph 9, my lord, Lordship will find the actual law. And it is settled, no dispute with it. In this case, my lord,
same, on same proposition.
no, this is something exactly under the purview of this case of one Madhya Pradesh High Court. In Lordship, you may peruse paragraph 20, 15 and 20. 15, 19 and 20, MP High Court. In paragraph 15,
No, no, in which judgment you are referring paragraph 15?
15, 19, 20, Madhya Pradesh High Court judgment, AIR 1986, MP.
You have not given any Madhya Pradesh High Court judgment.
Lordship may take it. Fifteen, itu move.
Yes,
Itu move. Attack. In paragraph 15, No. Okay. May I address?
Etulo.
Wrongly. May I read out thereafter I will place on record number.
Yes.
In paragraph 15 of this MP High Court judgment, it is observed that in the present case, the decree holders had already applied for execution and paid process fee for issuance of a warrant of attachment. It was therefore for the court to issue a warrant of attachment of such property as was in possession of the judgment debtors. Submission of the inventory of movable property in possession of the judgment debtors is not necessary under the relevant rules. In case the warrant is returned unexecuted, the decree holders could in their discretion make an application for examination of the judgment debtors under order 40 rule 41 or could resort to any other mode to recover the decretal amount. Thereafter, my lord, in relevant portion 19, I have pointed out the above fact there is a specific provision for dismissal of suit for non-payment of costs. So in order 9, while there is no analogous provision in order 21 of CPC. Consequently, the dismissal of execution application for non-payment of process fee or for failure to comply with the direction of this court will be in exercise of inherent powers. In the present case, the dismissal was not for failure of the decree holders to pay process fee or to submit a list of property, but it was in default of appearance of the decree holders. The courts below committed a mistake in treating the dismissal of execution application under order under Rule 105 so as to attract Rule 106 of Order 21 of the Court. The orders passed by the courts below cannot be sustained. Thereafter, in paragraph 20, my lord, since the dismissal of the execution application on 21/8/1979 was under inherent powers, the application for restoration will be by invoking inherent powers of the court, and in that even no time limit is prescribed for invoking inherent powers of the court. That is the proposition. So inherent power to exercise inherent powers, there is no time limit, and it can be exercised at any point of time in any cases. There is no bar. When there is substantial justice is in question. And Supreme Court judgment says wrong provision is not enough to disentitle the parties to get original substantial relief. In this way, the law laid down by the, then next time relying on Apex Court judgment, which I have only single copy, my lord, just I have point out. In the judgment, lordship, the regards of 161 CPC is observed that very wide, and it can be exercised at any point of time in any manner to cause the real justice to the litigants. So this will very helpful to support the case of the petitioner.
Heard Mr. A. Paul, learned counsel for the petitioner. None appears for the respondent on call. It appears from record that on last date also, that is on 24/7/2024, no one appeared for the respondent on call. Therefore, this case shall be heard ex parte against the respondent. This case shall proceed ex parte against the respondent. This application under section 115 of the Code of Civil Procedure, 1908, read with section 151 of the said code, has been filed by the petitioners impugning the judgment, and order dated 12/3/2021, passed by learned civil judge Baksa in Miss Appeal number 3/2019, whereby the order dated 9/5/2019, passed by learned Munsif Baksa in Miss J case number 9/2018, was affirmed. The facts relevant for consideration of the instant civil revision petition, in brief, are as follows. That who was the plaintiff? Your predecessor in interest.
Yes, no, one is died, Mr. Govinda Baro is expired and his name is substituted by his wife, Sarojini.
Who are the plaintiff?
You are the plaintiff.
All of
All the petitioners are plaintiff and degree holder.
the petitioners,
There are 4 petitioners.
petitioner number 2, 3, and 4, and the predecessor in interest of petitioner number 1 had filed a suit, had filed a title suit bearing
court of-
bearing number 4 of 2010 before the court of
Learned Munsif
Lalit Munsif at Rangya, praying for declaration of right title and interest, as well as for permanent injunction and eviction of defendant number,
all the defendants.
eviction of the defendants from the suit land. The defendants contested the suit by filing written statement. Stop. However, after the trial, after completion of the proceeding, the suit was decreed decreed by the Court of Learned Munsif Rangya by judgment and order dated 26/8/2015. Stop. Next para. Thereafter, the petitioners/decree holders filed a title execution case number 5/2016 in the Court of Munsif Rangya. Stop. On 29/5/2017, the executing court dismissed the execution case number 5/2016 due to absence of the decree holder on that day in the said court, before this, in the said case. Stop. Against the, stop, next para. Against the said dismissal order, the petitioners referred, and where is the application?
Page 66. Miss case number 57 of 2017.
Preferred an
Miss case.
application, filed an application under order 21, rule 106, within bracket 1, read with section 151 of the Code of Civil Procedure, 1908 for restoration of the title execution case number 5/2016. Stop, next para. However, comma, by order dated 9/5/2019, the executing court
Executing court
dismissed the said application on the ground that the decree holder not only remained absent on 25/4/2017 when, no, on
only 2 days.
on 29/5/2017, rather on many earlier dates also, the decree holder,
No, my lord. No. No,
that is the reflection.
no. Only 25/4/17, no access, steps taken on my learned counsel thereof. And on the next day, it was dismissed on 29/4/17. Otherwise, all proceedings were regularly
On
done.
25/4/2017, you were absent.
Yes, thereafter.
On 29/5/2017.
Dismissed. That is the only one date actually.
Okay. Yes, yes. No, but 29/5/2017. But on the previous date also, that is on 25/4/2017, the petitioner were absent. For what purpose that case was fixed on 25/4/2017?
For necessary steps. Actually, steps have already been taken. We have also already produced this when it was pending in the court of Rongia. Already delivered possession was ordered by the learned counsel.
Stop. Against the said dismissal order, the above named petitioner preferred.
Steps was already taken when
Okay,
it was pending
okay.
before the court of learned Rongia.
Against the said dismissal order, no, I will mention it later on. Said dismissal order, the petitioners preferred a misappeal before the Court of Learned Civil Judge Baksa, which was registered as misappeal number 3/2019. The said miscellaneous appeal was also dismissed. On the ground that
Quoting wrong provision.
on the ground that as the title execution case number 5/2016 was not posted for hearing on 29/5/2017, and therefore the dismissal was not made under sub-rule 2 of Rule 105. Dismissal was not made under Order 21, Rule 105 within bracket 2 of the Code of Civil Procedure. And hence it was held by the First Appellate Court that the provisions of Order 21, Rule 106/1 within bracket 1 would not be applicable in the said case, and therefore the First Appellate Court declined to interfere in the order which was order of the executing court. Declined to interfere with the impugn order of the executing court. Stop. Mr. A. Paul, learned counsel for the petitioner, has submitted that the title execution case number 5/2016 was not fixed for hearing on 29/5/2017, and it was dismissed for default only. However, he also submits that as there is no provision for dismissal of an execution case for default, the court and the executing court, while dismissing the said case, exercise its power under Section 151 of the Code of Civil Procedure, and therefore same can also be restored by invoking provisions under Section 151 of the Code of Civil Procedure. Learned counsel for the petitioner has submitted that though the petitioner was wrong in filing an application under Order 21, Rule 106 of the CPC, as the execution case was not fixed for hearing of any application on the date when it was dismissed, however, the petitioner had also mentioned Section 151 of the Code of Civil Procedure in his application, and it is submitted by learned counsel for the petitioner that the executing court as well as First Appellate Court ought to have invoked Section 151 for restoring the execution petition. In support of his submission, learned counsel for the petitioner has
1966.
has cited a ruling of the Apex Court in the case of Messrs. Ramchand and Sons Sugar Mills Private Limited, versus Kanhaiya Lal Bhargava and others, reported in AIR 1966 SC 1899. Wherein the apex court
There are five.
has discussed the scope and ambit of section 151 of the code and has observed that the scope and ambit of section 151 of the CPC are wide enough to give justice in wide enough to are very wide. Stop. It also observed that the inherent power of the court is in addition to and complementary to the powers expressly conferred under the code. Stop. But the powers will not be exercised if its exercise is inconsistent with or comes into conflict with any powers expressly or necessary implication conferred by other provision of the code. Stop. Learned counsel for the petitioner has submitted that there is no provision in the code for dismissal of an execution case for default. Similarly, there is no provision for restoration of such a case after such dismissal order. Hence, it is appropriate that the powers of section 151 of the Code of Civil Procedure should be invoked under such circumstances. Learned counsel for the petitioner has also cited a ruling of Madhya Pradesh High Court in the case of Khup Chand Jain and others versus Kashi Prasad and others, within bracket, in order dated 13/11. It is reported. No, not within bracket. Reported in AIR 1986, Madhya Pradesh 66, wherein the Madhya Pradesh High Court observed that where the dismissal of an execution application is under inherent powers, the application for its restoration will be by invoking the inherent powers of the court. And in that event, no time limit is prescribed for invoking the inherent powers of the court. Stop. I have considered the submissions made by learned counsel for the petitioner and have perused the materials available on record. I have also gone through the judgments cited by learned counsel for the petitioner. On perusal of the record, it appears that the title execution case number 5/2016 was dismissed by the executing court as the decree holder was absent without any steps on that date. It is apparent from the records that on that day, the
Decree holder number 1 was in.
on that day, the said execution case was not fixed for hearing of any application. Hence, but it was fixed for taking of steps for what purpose?
For eviction of the judgment debtors.
Taking of necessary steps by the decree holders.
But already steps taken while it was pending before Rongia. And an order of the London Munship is also before your lordship.
No. As the said execution case was not fixed for hearing of any application, the said case could not have been dismissed under Order 21 Rule 105 within bracket 2 of the Code of Civil Procedure. And it has to be considered, it has to be treated that same was dismissed in exercise of inherent powers of the court as observed in the case of Khubchand Jain and others versus Kashi Prasad and others within bracket Supra. Though there is no bar for filing a fresh execution case within the period of limitation again by the present petitioner. However, as the execution case which was filed by the petitioner had progressed fairly and orders for issuance of writ was passed by the executive
Munship Rongia.
Learned Munsif Rangia, and the petitioner also took steps in pursuant to the said orders. This court is of considered opinion that as the limitation period for filing execution case is not over, the ends of justice would be met if the execution case number execution case number 5/2016 is restored again. Stop. As regards the impugn order of the first appellate court is concerned, though the first appellate court refused to interfere with the order passed by the executing court on the ground that the decree holder filed the suit for restoration of the execution case under Order 21, Rule 106 within bracket 1, read with Section 151 CPC. And as rightly held by the first appellate court, the provision of Order 21, Rule 106 within bracket 1 of CPC is not applicable in this case. However, the first appellate court, considering the circumstances of the case, could have invoked Section 151 of the CPC for directing the restoration of the title execution case number 5/2016. After considering the facts and circumstances of this case, and for the reasons mentioned herein before, this court deems it proper to exercise its inherent powers and order restoration of the execution proceeding, that is execution case number
EX 560.
title execution case number 5/2015
16.
pending before the Court of Learned Munsif Baksa. Consequently, the present revision petition is allowed, and the impugn orders of the courts, of both the courts, namely Court of Learned Munsif Baksa as well as Court of Civil Judge Baksa, are hereby set aside. no orders as to cost. This civil revision petition is accordingly disposed of.
Can it be fixed any time for continuance of further proceeding of the court bill? Lordship may kindly fix a time within 1 month. Within a period of 1 month. Otherwise, they will keep it.
The petitioner shall appear before the executing court on,
Within a period of 1 month. Relative.
no, let me give a fixed date.
After 15th August.
No, within a period of 1 month, along with a certified copy of this judgment
Yes.
and take necessary steps before the executing court
For further proceeding of.
for further proceeding of the execution proceedings pending. No. Before that, the executing court is directed to restore the title execution case
TX
number
560.
number
TX 5/16.
TF 5/16. In pursuant to the directions passed in this order. And thereafter, the petitioner shall appear before the executing court within a period of 1 month from the date of this order, along with a certified copy of this judgment, and take necessary steps before the
Executing court.
executing court as directed by the executing court.
Okay.
Yes, Lordship. Well, this petition, my lord, has been prepared against the Impun order dated 1/10/22. Must be 100 Munsif Mongol. Lordship will find page 199. The Impun order.
This is fixed for admission.
Yes, my lord, admission.
We'll admit it.
No, my lord, the question is that, my lord, there is a question of repairing of the house of the petitioner, my lord. There was a status quo order.
Whether service is complete or not.
Service has been completed, my lord. But for last 2 or 3 occasions, they are not appearing. They are avoiding my lord appearance because of the fact that they are having the status quo order plaintiff. I am for the defendant, my lord. My house is on the part of their land, of the suit land, and there is a residential premises, my lord. Temporary or some type house, and during rainy seasons from 22, order was passed, my lord, in 1/10/22. Repairing order was passed on 26/5/22, but that could not be complied with because of the, my lord, the plaintiffs are restraining by the muscle power and other things, my lord. The petitioner is also filed FIR before the concerned police station. Police station has refused to provide any help on the, either it is a matter is submitted before the civil court. But the learned trial court has dismissed my petition under 151 for providing any police help by the Impun order.
No,
So-
at what stage is the,
Stage is, my lord, suit is at evidence stage, my lord.
at what stage?
Stage of hearing, evidence, my lord, evidence,
Okay,
evidence. So, my lord,
and before the trial court, the suit is contested by the,
contested, my lord. I am the defendant, my lord. I am the defendant number 3.
then we'll admit it and fix a date for hearing, short date. They may appear. The defendant,
For last, my lord, it is a suit of 23, matter has been, so, my lord, at the administration stage, next date may be fixed on any hearing date, my lord. Small matter, my lord, whether
Okay,
court
we-
has the power.
no, okay, we are
it's a-
admitting it. Today it is fixed for admission only, specifically mentioned.
At the administration stage, my lord, maybe hearing that may go for further and delay, my lord, so. So next hearing that may be fixed, let them they may appear, or otherwise, my lord, matter may be. Or lordship may mention that, my lord, if they will not appear in the next day, matter will be heard ex parte, my lord.
Yes. Heard Mr.
Yes, no.
S. Nath, learned counsel for the petitioner. None appears for respondent, though the service on the respondents has been held to be, though the notices on the issued to the respondents have already been held to be duly served. Stop. Learned counsel for the petitioner submits that there is an urgency in the matter as the petitioner is also praying for repairing of his
Residential house,
residential house, which is the subject matter of the suit,
a part of portion of such
which
matter.
is also the subject matter of the suit property, which is also the part of the suit property. Stop. Considering the urgency in the matter, let this matter be fixed for admission hearing on when?
Any hearing day, my lord? Maybe on, my lord, 13,
16.
16. 16 is Friday, my lord.
13.
13, my lord.
On 13/8/2015, it is hereby made clear that if the respondents fail to appear on the next date fixed, this revision petition shall be heard in their absence. List accordingly.
Please.
What is this?
Lordship, the present appeal is been filed challenging the order passed by the Honorable Railway Claims Tribunal in OA 268/2012, wide order dated 17 April 2024. Lordship, in this order, the tribunal dismissed the claim of the appellant of the illegal collection of the terminal charges.
What is terminal charges?
Lordship, whenever a consignment has been booked via railway at the originating station and at the destination station, railway imposes terminal charge. And according to
No,
circular,
what is terminal charges? That I want to understand.
Lordship, terminal charges are a notified terminal station. Lordship, if you may look upon annexure 2, page number 89. It's a circular dated 5/6/2007, which states that these are the mandatory facilities. There are various facilities been mentioned, like 15 to 20 facilities mentioned. And it is mandatory for the railway to provide the same. And once the facility has been developed, that station will be designated as a terminal station. And for that,
Terminal for what?
terminal charges for providing such facilities.
What facility?
Lordship, page 89.
Loading, unloading.
Various facilities, Lordship, I would just.
No, my query was, what is terminal charges? Whether it has been defined somewhere.
No, Lordship, it has not been defined anywhere as per the first time, as per annexure 3, in page number 97, it was the first time the railway brought the concept of the terminal charges. And Lordship, it is already a covered case, Honorable Guwahati High Court in two
No, no.
judgments.
Don't go fast.
Yes, Lordship.
My query you have not answered.
Yes, Lordship. Lordship, terminal charges has been not defined anywhere. Terminal charges are basically a notified terminal station. In the notified terminal station, whenever any kind of a consignment arrives or originates, terminal charges is levied by the railways.
No. If we don't understand what is terminal charges, how will we adjudicate on your plea that the railway impose excessive terminal charges. Okay, who is appearing? You are appearing for railway. When we are issuing notice
Much of it.
and whether any records will be necessary.
Lordship, lower court record, LCR,
And on next day you answer my query.
much of it, Lordship.
Heard Mr. What is your name?
Divyansh Rathi.
Divyansh Rathi, learned counsel for the petitioner. Also heard Miss
R Devi,
R Devi, learned
CGC.
Central Government Council, CGC, appearing for all the respondents. This appeal under section 23 of the Railway Claims Tribunal Act, 1986-87 has been filed by the appellant Messrs. Mahesh Enterprise Private Limited, impugning the judgment and order dated 17/4/2024, passed in original application number OA 3 Roman 3-2A268 slash 2012 by the Railway Claims Tribunal in Guwahati, whereby the prayer for reimbursement of what terminal charges and
Lordship, just terminal charges.
only terminal charges.
Yes, we were granted penal under charges on allegation of overloading. We are just challenging the terminal charge, illegal collection of terminal charge.
Was not allowed by the learned tribunal. Issue notice to the opposite parties. Since Miss A. Devi,
R Devi.
R. Devi appears for all the respondents, no formal notice need to be issued to the respondent side. You have furnished the memo of appeal. You have already furnished.
Yes, let's say extra copy more than maybe so.
Okay. Let the case record of OA let the case record of original application number OA 3268/2012 be called for from the Railway Claims Tribunal Guwahati bench. The registry to take steps for requisitioning the record. Let this matter be listed after 4 weeks.
Lordship, a short date.
After
It is a
2
covered matter.
after 2 weeks
Much obliged, Lord.
on a date to be fixed by registry.
Lordship, if
Will you file any objection?
Yes, let's say
You will file it.
4 weeks, let's say. Time maybe like
The learned counsel for the railway learned CGS Central Government Council prayed for some time for filing written objection against the prayer of the appellant. The prayer is allowed. Let this matter be listed after 3 weeks, 4 weeks.
4 weeks.
Lordship is filing, they are filing the counter affidavit with the opposite counsel.
Yes. They will file before that.
Much of. Much of.
Obliged.
May I please file? Lordship, I have filed this first appeal against the order 29/4/2024 passed in Miss J case 170 of 2024 in TS 140 by the Senior Division 3 of Civil Court, Guwahati. On the ground, my lord,
Where is the impugn order?
pardon.
Where is
Impugn order is page 17, my lord.
7-0.
7-0. 7-0. Effective parties, my lord.
You are appearing for respondents.
My lord.
All the respondents.
72, whereas 7 matter as such constraint above the test granting the injunction, both the parties maintain the status quo. So that is the order.
Yes.
My lord, in this case, my lord, in ground of my appeal, my lord, the suit was filed surpassing the material fact. The fact of the case, my lord, the respondent filed a title suit before the civil judge number 3, Kamrup Metro, and seeking partition, declaration, and khas possession, and permanent injunction and mandatory injunction. And along with the in this case, the 70 order 39 rule 1 and 2. In title suit, my lord, they have paid for partition. But the land they have also got from the ancestral property, and we are also getting ancestral property, and that property was get before 40 or 50 years ago. And my lord, they have got their share before 40 years, and they have sold out the 90% share of their land. And thereafter, they claim again partition. So my kindly see their title suit, my lord, what they have paid.
We're at page.
Page 30, their payer, my lord. Title suit, page 30, my lord, payer portion, my lord. Next, B, my lord. Lordship body.
Yes.
Decree for declaration to effect that the plaintiff being the legal heir of the Dharmaram Medhi died on 2012-2099. This is son of Ghanshyam Medhi, alias Ghanakanta Medhi, are entitled for 1/7 share of the schedule property A to F. Joint properties. Now I come to A to F. A to F property, my lord. How much property is there, my lord? Kindly. Here is the page 11, my lord, of my appeal memo.
Yes.
See table 1, my lord. A, B, C, D, E, F. That is the schedule property. And A property schedule, my lord, 1 bigha 4 lessa. B schedule, my lord, 4 bigha 3 katha 18 lessa. C schedule 9 bigha 4 lessa. D schedule 8 bigha. E schedule 5 bigha 2 katha 10 lessa. F schedule 16 katha 3, 16 bigha 3 katha and 16 lessa. Total, my lord, 45 bigha 17 lessa. Now, my lord, come to the page number 12, my lord.
Yes.
My lord, this sold out the property B schedule from B schedule, my lord, 2 bigha. And from D schedule, 4 bigha 3 katha, 3 bigha 2 katha 10 lessa. And total land they have sold 5 bigha 2 katha 10 lessa, my lord. And table 3, my lord, 1 bigha land they have possessed till now. Now that they have sold out this land by the sale deed, I have annexed, my lord, kindly see the page 73, my lord. land sale agreement, my lord, to Sri Biren Boru by the Dipti Medhi, my lord, that is respondent, my lord. Vernacular, my lord, only stated in page 85, my lord.
This is agreement to sell.
Yes, my lord, exhibit 6, my lord, 73, page 73. My
This
lord,
is
vernacular portion, my lord.
only agreement to sell.
Yes, another sale deed is there, my lord. That is the agreement for sale, and they have handed over the possession. And another sale deed is there, my lord, which was registered sale deed, my lord. That is a page 80, my lord. Page 80, my lord.
How much land they have sold total?
By this sale deed, my lord, 3 bigha 2 kotha 10 lesa, my lord. 3 bigha 2 kotha 10 lesa, my lord. And
Okay.
by the agreement, my lord, they have sold 2 bigha, my lord. And total land they have sold, my lord, 5 bigha 2 kotha 10 lesa, my lord.
Okay.
Now, as per their pair, my lord, A to F schedule, my lord, total land is 45 bighas, 10 less. And if it is divided in 7, my lord, then it's come 6 bigha, 10 katha, 5 less, my lord.
Yes.
Out of that, my lord, they have sold out 5 bigha, 2 katha, 10 lessa, and possess 1 bigha. That means they have 6 bigha, 2 katha, 10 lessa. And each come to every year 6 bigha, 6 bigha, 2 katha, 5 lessa. My lord. They have 5 lessas more land they have got, my lord. And now, my lord, where is the case, my lord? According their plane, they have got their share, and that fact, that material fact, my lord, they have suppressed. in
What
their-
they have, what they have suppressed that they have sold on.
Yes, my lord.
That selling
That
is,
portion they are not staying in their title suit, my lord. Plain, my lord.
you contested this order 39 rule 1 and 2
Yes, my lord.
application.
I have contested, my lord.
There you have mentioned.
Yes,
that-
my lord. Already I have stated already everything, and I have given some citation also, which was as by the apex court as well as the High Court of the Delhi High Court also. It was not considered. If the material facts are pressed, my lord, then the discretionary relief may not get. That is the case 1 decided by the apex court, Rampriti Jadhav, my lord. This is the case, my lord.
What was the reasoning given by the, now you are here against the order of status quo.
Yes, my lord. My lord, they have their part of the land, my lord, they have sold. And
No, no, during the pendency of the suit, how you would be prejudiced if the status quo is maintained?
because that is our land, my lord, that's land we are cultivating, and others, if the
Then you
status quo,
continue cultivating, the status quo has already been granted.
the status quo is there, and there no land is there.
They
Their
have
side-
1 bigha land according to your
Yes,
submission.
that land is they are occupying, my lord.
They will continue to occupy that land during pendency of this suit.
Yes, they can.
The court of this scenery where the suit is pending,
Suit is pending civil judge senior division 3, my lord. Guwahati.
the trial court has only directed to maintain status quo. How it will harm you? You maintain status quo. Status quo means if they are possessing 1 bigha land, they will continue to possess that.
Yes, my lord. That's part I am not going to say that their land they can possess. And already this land was divided since before
No,
40 years and 60
What
years.
is now? What is your grievance in
My
maintaining
grievance, my
status?
lord, if the status quo is there, my lord, we cannot do any further works in my land, my lord. If I am going to mortgage or any part for my benefit, my lord, we can't do it because their land is not there. All the lands is our lands, my lord, which was our part. Actually, there is no case because according them, they have got their share, my lord. So there is no any.
No, but the, if someone sell or mortgage the property, then the issue of partition, the issue, it may not, it may be difficult to, for the trial court to decide. If-
That's all right, my lord. Their demand, my lord, they have stated there is a 45 bighas land, my lord, A to F schedule, my lord. Accordingly, they have got their share, my lord, 6 bigha, 10 katha, 10 lesa, 2 katha, for 10 lesa, my lord. And they have sold out their part, 5 bighas, 2 katha, 10 lesa. And another 1 katha they have possessed, my lord. Where is the case, my lord? Where is the prima facie? Where is the irreparable loss and injury in favor of them, my lord? And another case was decided by the apex court, my lord. If this material facts are pressed, my lord, then the discretionary relief may not get, my lord.
No, have you pointed out to the trial court that these,
Yes, my lord. That
Then-
decision already I have given to the
no,
court below, my
that
lord.
the respondents have already sold 5
Yes, my
bighas land,
Yes, my lord.
then what was the observation made by the trial court on your, how trial court dealt with your
Kindly going through the order, my lord,
page?
page 70, my lord.
Yes, what was the observation regarding that?
May read the order, my lord, but there are no
You-
any
You,
such.
you may point out directly where
No, my lord, they are not saying regarding the sale and others, my lord.
it is not discussed.
Yes, my lord,
It is not
not
discussed.
discussed.
Where have you pointed out? Show your written objection where
My lord, I have not filed a written objection, my lord.
before the trial court.
Yes, there I have filed, my lord, but here is not filed, my lord. Appeal.
Then how will we know that whether you have raised this point before the trial
Right.
court?
Kindly.
Your main point is that they suppressed material facts.
Yes, my lord.
And you pointed out to the trial court regarding this suppression. You have to show to this court that you pointed out that fact. Apart from
Yes,
your
my lord, my
own,
written objection is there.
where? At
Page 58, my lord.
Where have you mentioned?
Page 54, my lord. Relevant part, my lord, 63, my lord,
Page
already
50?
58, my lord.
Yes.
My objection, my lord.
Yes. Where is the relevant part?
Relevant part 63, my lord, page 63, my lord. Already I have given the table, my lord, accordingly. Which was they have sold out and there I have already annexed these documents also, my lord. In 64, my lord, page 64, my lord, copy of the said agreement and sale deed, my lord. Annex are 2 and 3, my lord, in my objection. My lord.
Yes. Yes, Mr. Anything else?
No, my lord. Yeah. So my humble submission, my lord, that's it, and for hearing my, and my, I may consider the first statement.
I is also there.
I is there, my lord. For stay, my lord.
No, we'll dispose of we'll admit this. Yes, what is your submission?
My lord, the picture is not that much of beautiful as my learned friend, senior friend has presented.
Okay, okay. Then you are going to show one more picture.
Something.
Then I will take a short break.
Better.
Iman Hussain, Iman Hussain. Second of
No, then let us issue notice and call for the in miscase record. And in the IA, if we grant you relief, it would be giving relief in the main.
Exactly,
Because-
my lord. That is the final relief.
That would amount to final relief because the only status, if we revert, if we give any interim
My lord,
relief,
and we also want to file our objection, my lord, because in both petition, our pleadings are necessary.
okay.
Because without pleadings, my lord, the
In
picture.
IA also you are,
Exactly, my lord, because I am the
Yes.
caveator here, my lord.
Yes.
Since I am the caveator, there is no scope for ex parte order, my lord.
okay. Heard. Mr. A.R. Medhi, learned counsel for the petitioner. Also heard Mr. Your name is
S. Samoria.
S. Samoria. Appearing for the caveator / respondent. Since the Mr. Samoria has already appeared for all the respondents, no formal notice need to be issued to the respondent. However, you have received the copies.
My lord,
Okay. Stop. Need to be respondents. Let the, which is the only miscase record would enough.
Yes,
would-
ma'am.
Let the Miss J case, let the case record of Miss J case number 70/2024 within bracket in connection with title suit number 40/2024 bracket close be called for from the Court of Learned Civil Judge number 3 Kamrup Metro. It is hereby made clear that the record of title suit number 40/2024 need not to be sent by the trial court, and trial should continue to proceed in its normal course. Let this case be listed again on the learned counsel for the respondent submits that he may be allowed to file written objection. The prayer is allowed, same may be filed before the next day. Let this case be listed again on.
Short
Of-
date may be given, my lord.
Because these are the ladies, my lord, belongs to some other place, my lord. 4 weeks time, my lord.
After 4 weeks.
Right.
On a date to be fixed by registry.
Then, my lord, I may be considered till date, my lord.
No, granting relief would be,
Nothing, sir,
you
but-
also know that.
And my lord, status quo would not harm anyone, my lord, otherwise, my lord. It's a
No, that
family
we will
property.
decide.
Yes, ma'am.
There
It's
is-
a matter of merit, my lord.
This interlocutory application has been filed by the petitioner, by the appellant under Order 41, Rule 5 of the Code of Civil Procedure, read with Section 151 of the said code for staying the operation of the impugned order dated 29/4/2024, passed by learned civil judge number 3, Kamrup Metro, in Miss J case number 70/24, in connection with title suit number 40/2024. As Mr. S. Samoria has appeared for the opposite party, no formal notice need to be issued to the opposite party. The learned counsel for the opposite party submits that he will be filing a written objection against the prayer made by the petitioner. The prayer is allowed. Let this matter be listed after 4 weeks on a
My lord,
date,
date may be fixed, my lord.
on a date to be fixed by registry.
Right.
Registry will be.
My lord.
My-
Deeply.
In this regard, my another decision is there, my lord.
No, you take back these also. You,
time of hearing,
at the
madam.
time of hearing,
All right.
Let the all material come together, my lord. Deeply obliged.
Must.
My lord, by the impugn order, my lord, my prayer for injunction was rejected, my lord, on the ground that no monetary loss will be incurred to this appellants, my lord, and the appellants can be compensated in terms of money, my lord. My lord, what happened, my lord? The
no,
appellants,
let us issue notice.
and my lord, I have a prayer for injunction, my lord, because
No, not without hearing.
no, my lord, what happened, my lord? I'm only praying for a status quo, my lord, because if they sell the land, my lord, then my lord, whole this suit will be frustrated, my lord.
Where is the impugn order?
My lord, impugn order is at, it starts from page 55, my lord. But the court has found that there is prima facie case. But my lord, by misreading the, my lord, clauses in the agreement, the court has come to the finding that there is.
What was the case?
My lord, case is, my lord, the appellant before a lordship is the plaintiff's, my lord. My lord, there is one agreement for sale between the parties, and the sale consideration is fixed at 68 lakhs rupees, and out of 68 lakhs, already 30 lakhs are already paid, my lord, as advance.
Land belong to defendant.
Defendant number one, my lord. Then, my lord, there is a condition that, my lord, the vendor, who is the defendant number one, will obtain the permission. Then he will hand it over to the purchasers, and then the sale deed will be executed, and at the time of execution, the remaining amount will be paid, my lord. But since, my lord, thereafter, the wife, who is the defendant number two, my lord, she has filed one objection before the authority to not to grant the permission on the ground that, my lord, earlier there was some factory, some establishments are there which are removed, my lord. So she has suffered loss. So defendant number one is the husband, but wife has filed objection to not to grant the permission, my lord. And thereafter, my lord, since nothing was done, then the suit was filed for a specific performance of contract, as well as for declaration that, my lord, defendant number two, he is the wife of defendant number one.
Then if wife is objecting, where is the apprehension that it may be sold?
No, my lord, she is objecting only for granting permission to sell in respect of this appellants before a lordship matter. But she has not raised any other objection, my lord. And my lord, we have paid already out of 68 lakhs. 30
No,
lakhs.
is there any proposal of selling? Why are you apprehending that it may be
My
sold?
lord, there are statements I have made that they are negotiating with some other persons to sell the suit.
Where is that statement?
My lord, in my mistake case, my lord, that is, it starts from page 27.
Where is that statement?
Yes, my
Exact.
lord, I'm coming to that now. My lord, page 34, my lord. Page 34 of appeal memo, my lord. Page 34, paragraph 6, my lord. In the middle part, it is written, my lord, that the relief suggested unless considered and granted by this honorable court, the valuable and precious rights and interests of the petitioner shall be in jeopardy, and very purpose of the filing of the suit shall be frustrated in view of the fact that the petitioners have also claimed for alternative. It is also anticipated that after getting the knowledge of filing of this suit, the opposite party of the defendant number one may alienate the Schedule B and Schedule A.
May
amended.
alienate.
As such, the subject matter of the suit is needed to be protected by way of an expert
No,
order.
no, we are issuing notice, nothing more than.
Only a status quo order, because.
No, on what basis? There must be some apprehension.
But my lord, in my this IA, I have also stated that, my lord, they are in talks with some other persons, my lord. My lord, in lordship may take my IA, my lord. Now they have instructed, my lord, that's why there is a specific statement in my IA, my lord. Paragraph, page 7, my lord, paragraph 8. Page 7, paragraph 8, my lord.
You have not taken this.
My lord, at that time they were apprehending, but now they have come to know, my lord, this is paragraph 8, my lord, that the applicants come to know that the respondents are negotiating with different persons for selling the suit land, and therefore if the injunction prayed for is not granted, that indicate.
No,
that it
this
will
is
go-
very general statement.
And my lord, my injunction was only rejected, my lord, by misreading the clauses in the, my lord, this sale agreement, my lord.
Let the other side appear.
My lord,
Mr.
my
Heard
lord, only I'm
Mr.
praying for a status quo, my lord, not more than that, my lord.
Heard
No
Mr. A.K.
prejudice will be
Gupta,
caused to them,
learned
my lord.
counsel for the petitioner. This appeal under order 43 rule 1 within bracket small r of the Code of Civil Procedure, 1970, 1908 has been filed by the appellants impugning the order dated 13/5/2024 passed by Learned Civil Judge Senior Division, Tinsukia, in Miss J case number 118/2023, arising out of title suit number 53/2023, whereby the prayer for grant of temporary injunction in favor of the appellants was rejected by the trial court. Issue notice to the respondents and call for the case record of Miss J case number 118.
That perhaps may not be required because I have annexed everything, my lord.
Okay. Issue notice. The petitioner shall take steps for issuance of notice on the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable on 31st of August. No, 30 August. 30 August 2024, list accordingly. In I also, this interlocutory application has been filed by the applicant / appellant under order 41. No, under order 39, rule 1 and 2, read with section 151 of the Code of Civil Procedure, 1908. Issue notice to the respondents. Same order. List on 30 of August.
But at least my injunction prayer may be considered on the next date, that much of the reason, my lord.
No, let us see. We are fixing it only because we intend to consider it. So no order is required.
Oh, like,
May please, your lordship. This is an MSc appeal, lordship. I need to file an IA, lordship. Some junior advocate had filed it, lordship, and passed over to me, lordship. No IA has been filed for staying the order, lordship, judgment, lordship. So
Okay.
2 weeks time may be granted, lordship.
In MSc appeal, notices were issued or not?
No, lordship. Notice may be issued, but that lordship may be.
It is within limitation.
Lordship, I had filed lordship for limitation period, lordship, I had filed that case, lordship, and IA, lordship, and that was allowed, lordship,
Limitation has been condoned.
condone, lordship.
Okay. Okay. Mr.
I'm
M. Bhagavati, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act has been filed by the owner,
owner, lordship. Owner,
by Shri Nipen Kumar Bhattacharjee, owner of the vehicle involved in the accident, impugning the judgment and award dated 29/6/2017, passed by the Motor Accident Claims Tribunal, Golaghat, in MSc case number 76 slash 2015, whereby a compensation amount of rupees 5 lakh was awarded with an interest of 6% per annum from the date of filing of the claim petition till realization in favor of the claimant respondent. There was no the liability was fixed on you.
Lordship, last page 14, Lordship.
Who has to pay the amount?
Lordship, the opposite party number 3 has a liberty to, that is the insurance company, has a liberty to recover the aforesaid amount compensation.
Against
along
that,
with-
you have approached this court.
Lordship,
Against that observation.
Lordship, against that observation, Lordship.
Okay. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondent within 7 days from the date of this order, returnable after 4 weeks. The applicant shall take steps for issuance of notice on the respondents by registered post with AD as well as by usual mode stop list accordingly.
Wait, this is the Lordship. Lordship, this is a statutory appeal filed against the judgment dated 6/1/24. We are challenging the quantum. And basically the quantum because employment,
Quantum only.
basically quantum.
Okay. Heard Miss R.D. Mujumdar, learned counsel for the appellant. This appeal under section 173 of the MBA Act has been filed by the appellant insurance company, impugning the judgment and order award dated 6/1/2024, passed by learned Motor Accident Claims Tribunal number 2, Kamrup Metro, Guwahati in MSC case number 1002/2022, whereby a compensation award of to the tune of rupees 90,58,810.61 paisa was directed to be paid to the claimant respondents. Issue notice to the respondents. The
Lordship,
appellant,
it has come for admission, so
I'll admit it. But notices are not issued.
yes, Lordship can admit it and notices.
Yes, admit this appeal. Let this appeal is admitted. Stop. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks.
Hello, bless you. And I have a IA also, Lordship, 2221 of 2024 for stay of the separate IA is there.
I also will issue notice
We can deposit 50%.
50%.
Yes, but withdrawal, let them come, Lordship, in the appeal, then Lordship can dispose of the IA by directing us to deposit 50% of the.
Heard Miss R.D. Mujumdar, learned counsel for the applicant slash applicant. This interlocutory application has been filed by the applicant who had preferred the connected appeal number MSC appeal number 361/2000 24, impugning the judgment and award dated 6/1/2024, passed by Motor Accident Claims Tribunal number 2, Kamrup Metro, Guwahati in MSC case number 1002/2022. This application has been filed for staying the operation of the judgment and award, staying the execution of the judgment and award dated 6/1/2024. Aforesaid judgment and award, stop. The learned counsel for the appellant has submitted that the connected appeal is mainly filed challenging the quantum of the compensation awarded to the claimant respondents. Considering the submissions made by learned counsel for the appellant, as well as after going through the application filed by the applicant, stop. The prayer for stay of the impugned judgment and award during the pendency of the connected appeal is allowed, subject to the condition that the applicant shall deposit 50% of the awarded amount before the registry of this court within
6 weeks.
within 6 weeks from the date of this order. With above observation, this interlocutory application is disposed of.
Highly obliged, Judge.
May I please your lordship? Lordship, this is a statutory appeal against the award passed by the Honorable Motor Accident Claims Tribunal for enhancement of the compensation.
Okay, heard Mr. A. Lal. What is your name?
M.K. Dev.
M.J. Dev, learned counsel for the appellant. This appeal under section 173 of the MV Act, 1988 has been filed by the claimant appellants, praying for enhancement of the compensation awarded to the claimant appellant by judgment and award dated 17/5/2024, passed in MSC case number 415/2021 by the Motor Accident Claims Tribunal number 2, Kamrup Metro and Guwahati. Issue notice to the respondents. No, before that, this appeal is admitted. Stop. Issue notice to the respondents and call for the case record of MSC case number 415/2021 from the concerned tribunal. The appellants shall take steps for issuance of notice on to the respondents by registered post with AD, as well as by usual mode within 7 days from the date of these orders. Returnable notices are returnable after 4 weeks from the date of this order, list accordingly.
May please your lordship. Lordship, in this case, I'm appearing on behalf of A. Photcharjee, lordship. This matter may be adjourned for 1 week, lordship. He's on legs in some other court.
We issue notice instead of that. Heard Mr.
T. Kolita on behalf of
T.
A. Photcharjee.
Kolita submitting on behalf of Mr. A. Bhattacharjee, learned counsel for the appellant. This appeal under section 173 of the MV Act, 1988 has been preferred by the appellant slash claimant, praying for enhancement of the quantum of compensation awarded to the claimant appellant by judgment and order dated 7/6/2024, passed in MSC case number 587/2018 by the Motor Accident Claims Tribunal number 1, Kamrup Metro. Issue notice to the respondents. The appellants shall take steps. No, before that, this appeal is admitted. Stop. Issue notice to the respondents and call for the case record of MSC case number 587/2018 from the concerned tribunal. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within a period of 7 days from the date of this order. The notices are returnable after 4 weeks from the date of this order, list accordingly.
Much. May it please your lordship. Lordship, this is an appeal by insurance company, lordship. We are challenging the quantum in the judgment, lordship.
Quantum.
Quantum.
Heard Mr.
People.
T. Kolita, learned counsel for the appellant insurance company. This appeal has been preferred under section 173 of the MV Act, 1988, impugning, challenging the quantum of the compensation awarded to the respondent's claimant by order dated 12/3/2024 in MSC case number 20/2021 by the Motor Accident Claims Tribunal, Lakhimpur. Issue notice to the respondents and call for the case record of MSC case number 20/2021 from the concerned tribunal. Stop. This appeal is admitted. Stop. Next. Learned counsel for the, learned appellant. No, the appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as through usual mode within 7 days from the date of this order, returnable after 4 weeks.
Lordship, there is a separate IA for paying for stay.
What was the
IA
quantum?
number 223524.
How much was the quantum?
Lordship, it was 48 lakhs, 3,725.
You pay
50%. 50.
Heard Mr. T. Kolita, learned counsel for the applicant. This application under Order 41, Rule 5 of the Code of Civil Procedure, 1908, has been filed by the applicant who has referred the connected appeal, that is MSC appeal number 364/2024, impugning the judgment and order dated 12/3/2024, passed by learned Motor Accidents Claim Tribunal, passed by the Motor Accident Claims Tribunal, North Lakhimpur in MSC within bracket death case number 20/2021, whereby an award of rupees, how much?
50%, lordship.
No, what was the awarded
Lordship,
amount?
48 lakhs, 3,725.
Award of rupees 48 lakhs,
Page number 22, lordship, of the IA.
48 lakhs, 3,725 was awarded to the claimant respondent. Stop. Considering the submissions made by the learned counsel for the applicant, as well as also considering the averments made in the application, the prayer is allowed. The prayer is allowed. The stop. The operation of impugned judgment and order dated 12/3/2024 passed in MSC case number 20/2021 shall remain stayed till the pendency of the MSC appeal number 364/2024, subject to payment of 50% of the awarded amount by the claimant, by the applicant/appellant to the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Much obliged.
My lord, I have filed this appeal against the order dated 34/2024 of MSCT member MSCT Kamrup Amingao, my lord.
Heard.
Honorable member dismissed the case, my lord, on the ground.
You are the claimant.
I am for the appellant
Oh, it was dismissed.
and a claimant, my lord.
Okay.
The appeal was dismissed on the ground that this is a case of GD&T, my lord. No FIR was filed.
Okay.
As per the honorable member, FIR was not filed.
Okay. Heard Miss D. Roy, learned counsel for the appellant. This appeal under section 173 of the MB Act, 1988 has been filed by the appellant/claimant impugning the judgment and order dated 30/4/2024 passed in MSC case number 101/2019 by learned Motor Accident Claims Tribunal Kamrup, Amingao, whereby the claim for compensation filed by the appellant was dismissed by the tribunal. Stop. This appeal is admitted. Stop. Let the record of MSC case number 101/2019 be called for from the concerned tribunal. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks. List accordingly.
Please, your lordship. Lordship, I have instruction to pray for an adjournment today, my lord. My senior colleague has some difficulty. Lordship.
Heard Mr. N. Zaman, learned counsel for the petitioner, who submits that due to personal difficulty of the conducting counsel, Mr. N.J. Datta, he prays for an adjournment, considering the ground mentioned by the applicant, by the petitioner, the prayer is allowed. Mr. Bosho, whether CD is there?
Yes, CD is there, Lordship. 15 notices.
Also heard Mr. K. Bosho, who submits that the case diary is available. Let this case be listed again on, they are seeking for it.
Any other date, Lordship? Because I have gone through the CD.
Okay. Then.
কেতিয়া সুবিধা হয়? ডক্টৰ ছাৰ নাই নেকি?
6, 7, 8, 6, 7, 9th,
My lord.
9th August.
CD to be retained.
The case diary shall be retained till next day.
Obliged, lordship.
May I please, lordship? This is a bail application, my lord, incarnation of Jalukbari PS case.
Case diary is there.
Yes, case diary receipt logs.
On the last date, my lord, the details of the case already has been noted.
How many days you have?
My lord, as
Complete.
on today, my lord, 54 days from the.
How many days?
54 days from 6/6/24, but he was shown arrest on 15th June. From
Since
that
then,
date, it is 45 days.
any submission, Mr. Bashir?
So sufficient materials are there. Actually, he is one of the mastermind in this matter. They do the all this stuff, they prepare all the documents and all. He was shown arrest from the this Lokasil police station case number. Others were taken to the police remand. Not he, that time interrogation was going on. Apart from his other co-accused statements are there. From their statements also, it is clear that he is involved.
Okay, heard Mr. M.A. Islam, learned counsel for the petitioner. Also heard Mr. K. Bashir, learned additional public prosecutor. This application under section 483 of the BNSS 2023 has been filed by the petitioner, namely Ramzan Ali, praying for Ramzan Ali, who has been detained behind the bars since 6/6/2024 for last 54 days. Stop. It is submitted by learned counsel for the petitioner that he has been shown arrest in connection with Jalukbari PS case number 99/2024 on 15/6/2024, and since then
45 days.
already 45 days have lapsed. E2 Nagor order dated 26/7, code paragraph number 4. 26/7 or code paragraph number 4. Code para number 5. 6. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 54 days in connection with Latasil PS case number 30/2024. And
54 days.
he has also been detained behind the bar in connection with Jalukbari PS case number 99/2024 since last 45 days. It is also submitted by learned counsel for the petitioner that in the meanwhile, the co-accused, namely Manoj Basfar and Fanindra Kumar, have already been granted bail by this court. Stop. Learned counsel for the petitioner has submitted that considering the period of detention already undergone by the applicant petitioner, he may be allowed to go on bail, and the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Jalukbari PS case number 99/2024 and has submitted that there are incriminating materials against the present petitioner in the case diary. However, he also submits that the investigation has fairly progressed in the meanwhile. Stop. Considering the submissions made by learned counsel for the before that, I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the case diary of Jalukbari PS case number 41, Jalukbari PS case number 99/2024. Stop. It appears from record that the petitioner has already been detained behind the bars in this case for last 45 days. And two of the co-accused are already released on bail. Stop. It also appears that the investigation has fairly progressed. Stop. Considering the progress in the investigation as well as period of detention already undergone by the above named petitioner, his further custodial detention does not appear to be necessary for fair completion of the investigation of Jalukbari PS case number 99/2024. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate, Kamrup Metro, with following conditions. Condition number 1 and 2. The bail application is accordingly disposed of. Send back the case.
Made, please, your
Yes.
May it please, your lordship. My lordship, this is a regular second appeal against the judgment and order dated at page 117, annexion 9. My lord, this is the second round of litigation. In the second round of litigation, the first round of litigation, the judgment, the matter was remanded back to the trial court, and the judgment is at page 91, annexure 6.
Remanded by the first appellate court.
By the second appeal, by the
Second appellate.
by the high court. And the judgment is at page 91. There, my lord, we were the defendant. We had won both the, we had won in the trial court. We had got a concurrent finding in the appellate court. Then the opposite party had come to the, had filed an RSA. My lord, annexure 6. My lord,
In the first round.
in the first round, my lord.
Okay. What was for the suit is for?
My lord, the suit is, my lord, there are two adjacent paddy field, and there is a bongia. Bongia is basically, my lord, way.
Okay.
So they are claiming easementary right over that land.
Okay.
My lord, the bongia does not itself has a existing and exclusive right. It changes every year when the paddy is again cultivated. So it does not have an existence of its own. So therefore, the section 25 of the Limitation Act, by why the easementary right has been given, that is the first.
To whom easementary right was given? To
It
you?
has been given to the defendant, my lord.
Through your land?
Through my land. We are the owner of the property. my
Both
lord.
plot?
Yeah, we are the owner of the property of the plot. And there is no dispute that we are the owner of the plot. My lord, in fact, in the written statement they have filed, they did not even claim an easementary right in the trial suit. In a trial, they didn't even claim an easementary right. We filed a suit in the trial for a negative declaration stating that they cannot have a possession over this road and they cannot have a possession over this way because this is our land and it cannot have an easementary right. Their first argument that they put up.
You did not file an injunction preventing them from using the right of way.
My lord, at that it was of 1992. At that time, my lord, they just filed just a simple plain stating for a negative declaration.
That they don't have right.
They don't have right, and that came in our favor. I mean, the first round of litigation, it came in our favor.
What was the finding?
Yes, my lord. The finding is at page annexure 3, my lord.
Page
54.
What is the finding?
The
Yes.
finding at 62, my lord. The case of the plaintiff is proved with mere preponderance of probabilities of, and thus the suit is decreed with cost. The plaintiff are entitled to recover khas possession of the suit land. It is also declared the defendant has not acquired right, title, interest of right of user.
That was for recovery of possession also.
Yes, recovery of possession of suit. My lord, our plaint is at page.
No, whether you were dispossessed, it was only easementary right.
It is easementary right. My lord, we had paid for a negative declaration.
But the relief is given of
We were given.
recovery of possession.
Yes, we are given recovery of possession because they were in possession at that time because they were using the road. So that is why the learned trial court had given us back the position, saying that you have the position over the land.
But if the land was used
Yes,
and if only right to way was given, then
But-
appropriate remedy ought to have been the injunction.
yes, it should have been, my lord, it should have been. My lord, our
Then
prayer,
what happened?
then my lord, matter went to the appeal.
They filed an.
They filed an appeal. The appeal, there's a concurrent finding for us.
How many petitioners are there? How many plaintiffs were there?
My lord, 29, my lord, when we filed or when
When the original. suit-
original, in the original, my lord, there were only 4 plaintiffs.
And how many defendants were there?
My lord, there are total 19 defendants.
The suit was filed by you actually.
Yes, my lord, suit was filed by me.
Okay, then what happened? The defendants filed the first appeal.
First appeal, my lord. The first,
How first appellate court decided?
my lord, that is at page 81. It decided in our favor only. Concurrent finding. We have already found that all the relief the plaintiff are entitled to vermins by trial court, and I find no reason to differ with such finding. Are we, my lord, may get it?
Yes, yes.
Accordingly, the judgment of the trial court is affirmed and this appeal is dismissed on contest with cost. Judgment is delivered in the open court and is given under my hand and seal, 11th day of August 2023.
Okay, then thereafter.
Thereafter, they filed an
Second.
second appeal. That is RSA 182 of 2003. At page 82, my lord. Annexure 5.
What was the substantial question of law which was filed?
My lord, the substantial question of law is at page 87. Now, therefore, the substantial question of law that arises, my lord, page 87.
This is the order or the, there,
Yes, the order is at page 6, annexure 6, my lord.
page?
Page 91, annexure 6. My lord, at page 93, my lord may see that the learned first appellate court framed an additional issue as follows: whether the defendant acquired easement right of a suit land for having urged it acquired by law for more than 20 years. So the learned High Court had decided that because there was an additional issue decided, therefore the matter should have been remanded back to the trial court to decide. And that is why, my lord, at page 95,
no substantial question.
no substantial law was decided. It was not decided on merit. It was just said that because the appellate court had framed an additional issue, therefore the opportunity should have been given to both the side to lay evidence, and therefore the matter should be remanded back to the trial court.
Trial court.
Yes, my lord.
Okay.
Now, my lord, this is the finding is that here, my lord, at page 95,
Yes.
that PW3 was 50 years of age. My lord, even if the defendant have led any evidence, the averments made in the would also go to the lease. There was a road in existence. PW3 is in the course of his cross-examination that he had been witnessing the road time of his childhood.
No, my query was
Yes, my lord.
in the first round of litigation, what
My lord.
was the substantial question of law?
In the regular second appeal, there was the substantial question of law was not framed. It was decided that because the learned appellate court had framed a question of law, additional question of law, therefore the matter should be remanded back to the trial court so that both the parties can lead evidence. My lord, that is the finding here. But that is where I was reading it at page 95, my lord.
Okay.
May I read, my lord?
Yes.
Yes. In view of the discussion made above at paragraph 30, my lord, this court feels inclined to take the second alternative.
No, we'll continue at.
Yes, my lord.
At 2 we'll.
Yes, the similar fate, my lord.
No, this time we'll continue at 2.
Yes, okay, man. Much obliged. Yes, madam.
Yes.
95, madam.
Yes.
In view of the discussion made above, this court feels inclined to take the second alternative referred to it in the preceding paragraph, and according the impugned judgment and degree is set aside, and the matter is remanded to the learned trial court.
This
for
is second appellate court's order.
Yes.
In second appeal,
Yes,
then it was
it
remanded.
was remanded back, madam.
Thereafter,
Thereafter, my lord, the matter came up before the learned trial court. My lord, the judgment is at page 101. Now, my lord, the effective part, my lord, make at 110, paragraph 20, my lord.
what it held,
In such a, my lord, it went against us. My lord,
dismissed the suit.
yeah, it dismissed the suit, my lord.
What was the reason?
20, my lord. Page 110, paragraph 20, my lord. May I read, my lord? In such an endeavor to discharge the burden, the defendant produced some documents before the court and marked exhibit Ka to Cha, which are respectively a copy of the certificate dated 18/5/1987, copy of the receipt 19/6/1999, copy of the receipt dated 29/3/1961, and copy of proposal of Gram Panchayat dated 26/3/1961. All these copy are original and the same are not public document as well. The defendant failed to state why they could not bring the original document before the notice of the court, and as such the same are not admissible in evidence. The documents which the defendant were reliable, they did not take, the honorable court said that they were not admissible. In such a situation, it is doubtful that the Panchayat took over the suit part for maintenance in the year 1961. It has been already decided the defendant failed to prove that the father of the plaintiff ever gifted the suit part to the rise of the locality. The Honorable High Court has also not interfered in such finding of the two court below. However, the oral evidence cannot be thrown out as a fact that the defendant and the people of the locality use the suit path since long. Our main concern is to see whether the defendant has been using the path without any interference for more than 20 years. In order to reach on a conclusive decision, I must depend myself upon more on oral evidence than the documentary evidence, because only the people of the locality would say how long they have been using the suit path. The plaintiff failed to nor any easement, nor any use path as public way. From the evidence as well as the additional evidence of defendant's side, it appears that there was an existence of suit path in 1961, and the defendant used the suit path as their way without interference from the plaintiff till filing of the instance suit in 1986. Even it is not officially proved that Panchayat took over the suit path and the government grant funded, the standard of proof in a civil suit is preponderance of probability, and the present suit, the preponderance of evidence leans heavily in the favor of defendant.
Okay, so
But they did not even take the documentary evidence which the opposite side, only on the defendant witnesses, they gave them the easement. Now, my lord, I have brought the defendant witnesses, some of the certified.
no, what the first appellate court held.
The first appellate court gave a concurrent finding. My lord, there is at page 125, my lord. At paragraph 14. My lord. May I read, my lord? Page 125.
Yes. What it held?
It is an admitted, page 125, my lord, paragraph 14. It is an admitted position quo, the pleading that there is a path. The question be answered is whether it has been used by defendant predecessor. Neither the plaintiff nor the defendant have pleaded the exact time since when the said path has been used by public. The oral
So
evidence.
appellate court also
Yes.
held that it was in existence since 1961.
Yes, only on basis of oral evidence. My lord may see
at paragraph 21. Paragraph 21.
Yes.
I have gone to the evidence of Circle Officer Jorhat PW5, disposed that defendant number 17 never encroached any part of the suit land in Dag number 690. There is no rebuttal of the said defense. The decision of learned trial court is affirmed as such. Even the Circle Officer gave a report in our favor saying that it is a paddy land and they have never encroached the land. They have never, that is the report of the Circle Officer, and that has been affirmed by the trial court. Only on oral evidence, they have given the entire easementary right that it has been existent for 20 years. Now, my lord, I would like one of the evidences.
Now, okay, now what substantial
Yes,
question
my
of
lord.
law you have formulated
My lord, the substantial question that I have put is at page,
stated?
yes, stated, my lord, is at page of 13, my lord. My lord, the second question, whether the right of easement under section 25 of the Limitation Act can be solely be established based on the defendant witness, more so when the defendant did not claim for easementary right, nor they have made any specific pleading to that effect. They never had any pleading in the written statement, my lord. Then, my lord, a fourth one, my lord, whether in facts and circumstances of the case, the learned trial court is legally right in deciding all the issues based on the evidence recorded deciding the additional issue. Only on the additional issue and the evidence that taken an additional issue, he has decided the entire plane.
No, but this is not substantial
So,
question.
my lord, then at page 14, my lord, whether the page 14, my lord,
Yes,
whether the section 25 of the Limitation Act is applicable in such cases where there is an alternative path.
what section 25 says,
26 of the Limitation Act, my lord.
what it says,
It says about the easementary when it has been,
read it.
yes, my lord. Accusation of easement by prescription, where the access and use of light or air to any building have been peacefully enjoyed therewith as an easement and as a right without interruption and for 20 years. And where any or water course or the use of any water or
No,
any.
whether you pleaded that there is an alternative path.
Yes, I have pleaded, my lord. Even the evidence of the DWs have stated, my lord. I've annexed it also. I've annexed it also. My lord may see. My lord may see page 98. Page 98, page 99, my lord. Page 99 at bottom. My lord, this is the defendant witness on which basis the evidence has been appreciated. ভূগোদয় মাথৰৰি পৰা আমাৰ ঘৰলৈ চৰকাৰে প্ৰণতে এটা ৰাস্তা নিৰ্মিত কৰে. And my lord, there is other evidences also, my lord. Moving on. Oh, this is another defendant witness. Even they have said, he's an independent witness. Even they have said that there's an alternative path. At page, my lord, the second page, at bottom. My lord, may I read?
Okay,
এইটো সত্য নহয় যে
okay, we are admitting. Heard Mr.
SP Sharma.
SP Sharma, learned counsel for the appellant. This appeal, this regular second appeal under section 100 of the Code of Civil Procedure, 1908 has been filed by the appellants impugning the judgment and decree dated 23/8/2023 passed by learned civil judge within bracket senior division Jorhat in title appeal number 10/2018, whereby it affirmed the decree passed by, which decree? Where is the,
My lord,
from the decree? Where is the trial court's decree?
the trial court's decree at, my lord, page 114, my lord. And the appellate court, my lord, decree is at page 133.
Decree,
133, my lord.
judgment and decree dated 16/7/2018. Passed in title suit number 162/1994 by the Court of Learned, which is the trial court?
My lord, in the Munsif 1, Jorhat, my lord.
Court of Learned, Munsif number 1, Jorhat. After hearing the learned counsel for the appellant and after perusing the memo of appeal and the documents annexed therewith, following substantial question of law is hereby formulated in the second appeal. Whether the provision of section 25 of the Limitation Act 1963 may be applicable for, what is the language of 25? Acquisition.
My lord, like, where the excess without interruption and for 20 years, and where any way of water course has been peacefully and openly enjoyed by any person claiming title as an easementary and as a right without interruption and for 20 years. The right to such access and use of other easements shall be absolute and indefeasible. My lord, this is the act. Limitation Act 1963.
You can. Applicable for acquisition, acquisition of easementary right by prescription, where there is an alternative path available. Number 2, whether the provision of section 25 of the Limitation Act 1963 would be applicable to Bongia within bracket. Bongia means way.
Way, paddy way, man, it's like. Used to cross paddy field, man.
Small way used to cross paddy field, bracket close.
My lord, it does, my lord.
No, second to none again.
My
Only one
No,
subsection.
my lord, because the Bongia does not have its own exclusive right in existence. So if a path itself does not have an exclusive right in existence, how can section 25 will be applicable, my lord? Because it's like a Mathwari, my lord, and Bongia. They always changes with the river course and the paddy field, my lord. Because here, my lord, may see an explanation.
Used for crossing the agricultural field, which does not have any.
Exclusive right in existence.
No, this is not clear. What do you mean by exclusive right?
Because, my lord, the existence
Which
of the
does
road.
not have any fixed existence.
Yes, fixed existence.
stop, issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 7 days from the date, within 3 days from the date of this order, returnable after 4 weeks.
But I have an
Please,
eye for
Rakesh.
space.
Stay, I'll issue only notice after their appeal.
My lord.
In I also, this interlocutory application has been filed by the petitioner / petitioner under order 41 rule 5, praying for stay of the execution of the impugned judgment and order which the applicant has, against which the applicant has filed a connected regular second appeal numbers 106/2024. Issue notice to the respondents. The petitioner shall, the applicant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 3 days from the date of this order, returnable after 4 weeks.
That's all.
The present appeal is preferred against the concurrent judgment on the both the learned court below. My lord,
Concurrent judgment. Concurrent judgment.
yes, my lord.
Okay.
Only one substantial question of law. Section 11 of the CPC. my lord. And what happened, my lord, the present,
What concurrent judgment, what substantial question?
my
you
lord, yes, my lord, only one substantial question involved in this case, my lord. At page my lord 8, my lord. Question number 1.
Yes. How?
Yes, my lord. The present plaintiff, my lord, in the year 1988, purchased the Shudland by two registered sale, my lord. One is 1126 of 88 and another 1621 of 1988. And after purchasing, he entered into the position. And subsequently, when he proceed to develop the Shudland,
No,
but
the
artfully,
plea of res judicata
yes, my lord.
was not taken by in first appellate court.
My lord, yes, my lord. The prior to filing of the suit by the present plaintiff, appellant, my lord, the respondent number 1, 2, and Ishaq Ali, the father of the respondent 6 and 7, filed another suit, my lord, in the year 1993, my lord. And that suit was against the present plaintiff, appellant plaintiff, suit only for permanent injunction, my lord. And that suit was decreed. After disposal of the suit, the present plaintiff filed a suit, present plaintiff appellant has filed the present title suit, before the learned court of Sodor Munship Tezpur, my lord, for with a praying for a decree for declaration of his right title interest and for recovery of possession. But the learned could hold that earlier the suit filed by the respondent was relating the same plot of land, same party. So that was, but same relief was not prayed. That was the substantial question of law involved under section.
No, the question of res judicata was decided by the first appellate court. Again,
Title suit and in the first in the trial court as well as first appellate court.
what was decided? That the present suit is barred by res judicata.
Yes, ma'am.
Because in 1993, the matter was earlier decided.
Already
Already
decided.
decided.
But
Now,
But
Now, what is the substantial question of law in second appeal?
Yes, my lord. Page 8, my lord. 1. Page number 8, point number 1. Whether the impugned judgment and decree passed by both the learned court below dismissing the suit of the appellant for a decree of declaration of right, title, interest, and recovery possession of the suit land is hit by section 11 of CPC, where the earlier title suit number 62 of 1993 filed by the respondent against the present appellant over the same suit land was decreed only for permanent injunction.
Okay.
Earlier suit is decreed only
Your
for
plea is that as because subsequent suit was for declaration of right, title and
yes,
interest.
yes. That was not decided in the earlier suit. In the earlier suit only for permanent injunction. I was restrained by way of permanent.
Then whether the principle of res judicata is applicable. or not.
Yes. That question is. My cell, the registered sale deed by which we have purchased was not challenged in the earlier suit. It is still unchallenged. Same.
Heard Mr. P. Das, learned counsel for the appellant. This is PP Das, sorry, PP Das, learned counsel for the appellant. This appeal, this regular second appeal under section 100 of the Code of Civil Procedure, 1908, has been filed by the appellant impugning the judgment and decree dated 1/9/2017 passed by the Court of Learned Civil Judge Tezpur in title appeal number 8/2016, whereby it
Trial court is Sodor Munshi Tezpur.
affirmed the decree.
Confirming it
Where-
passed by the learned.
whereby it affirmed whereby it affirmed the judgment and decree, whereby the judgment and decree dated 29/2017 passed by Court of Learned Munsif 1 Tezpur in title suit number 60/2006 was upheld. After hearing learned counsel for the appellant, as well as after going through the memo of appeal and the documents annexed therewith, following substantial question of law is formulated in this second appeal. Whether the impugned judgment and decree passed by both the courts, namely Court of Learned Civil Judge, Sonitpur, as well as Learned Munsif number 1, Sonitpur, whereby the suit of the appellant for decree of suit for the appellant for declaration of right, title, interest and recovery of khas possession of the suit land was dismissed on the ground that it is hit by section 11 of the Code of Civil Procedure as the earlier title suit number 62/23 filed by the respondents against the present appellant over same suit land is correctly held in view of the fact that the earlier suit was only in respect of in earlier suit, the relief sought for was only permanent injunction. Bracket close. Issue notice to the respondents. The appellant shall take steps for issuance of notice to the respondents by registered post with AD within and by usual mode within 7 days from the date of this order, returnable after 4 weeks. Let the case record of title appeal number 8/2016 as well as title suit number 60/2006 be called for from the concerned court. This
Hi.
recording.
But in this case, the appeal has been dismissed my lord, by the learned First Appellate Court on the ground of being barred by limitation. My application for condonation of delay in filing the appeal that was dismissed. Hence, the main appeal has never been taken up on merits. Against this order, my lord, that I have come today. Though the court of the learned Munsip also has decided against us. That is the order that we challenged on by filing.
What is
appeal.
the substantial question of law?
Lord, the substantial question of law I have prepared separately. If I may just.
Where?
I have. Just.
No, it has to be there in the memo of appeal.
But then I'll have to bring it.
That
by
is the
way of-
requirement of law,
Okay, but I will file an affidavit in that case.
not affidavit. Amendment, you amend your memo of appeal. So what is your prayer?
But my.
This is my suggestion only.
Well, Lord, there can be two ways, my lord. Either I can file an affidavit or I'll have to amend the entire thing.
That is your choice, but I am just,
let
because
me-
law says that
It has to.
it has to be in the memo of appeal.
That is there.
So
Earlier,
how
my
to
lord,
bring it?
Normally, when earlier the practice was, we often used, sometimes it came in the memo of appeal. Sometimes we used to hand it
No,
over.
but what is the law?
The law, if I go by the law, it has to be.
You have to go by the law.
Yes, that is there. But,
Then what is your prayer?
let me take instruction and matter may come up next week.
Okay. Third, Mr. A, what is your name?
A. Ganguly.
A. Ganguly, learned counsel for the appellant who prays for some time for taking necessary instructions in connection with this appeal. The prayer is allowed. Let this case be listed after a week on a date to be fixed by registry.
So my appeal has also been dismissed by the learned First Appellate Court Lordship. Trial court judgment has been upheld Lordship. I have framed two substantial questions of law that is immediately after the index Lordship in my petition Lordship.
Where?
Immediately after the index Lordship.
What is the case
Yes, Lordship,
in a nutshell?
I have prepared a title suit, Lordship, for the.
You were the plaintiff.
Lordship, we had a plaintiff, Lordship, in the trial, Lordship. And we have challenged the sale deed, Lordship. On the ground that, Lordship, the petitioner.
But this system is also not okay.
Lordship,
Your substantial question of law should be there in the memo of appeal,
Lordship.
not separately. That is what I understand by reading 100. So that has to be followed.
Lordship.
It cannot be tagged separately.
Lordship.
It has to be part of memo of appeal. If I,
I will be allowed to amend, Lordship. Then.
the memorandum, yes, it has to be heard, Mr. R. Fukan, learned counsel for the appellant, who prays for some time for filing an amended memorandum of appeal. The prayer is allowed. Let this case be listed after 2 weeks.
Obliged.
Yes,
May I please, Lanet, council amicus curiosity, amicus is that is in on legs in court number 10, Lordship. It may be taken after some time.
after some time.
After some time, because your Lordship is supposed to be disposed of today. He is here, coming.
But it has come in orders column.
Here, in the last occasion also it was coming order.
Okay, after some.
After some time, funny, he is the amicus curiosity.
Please, Lord. My lord can close this, Lord, CRP, my lord, as being infractions.
Heard Mr. S. Hajorika.
B cost.
B. Heard Mr. B. Kaushik, learned counsel for the petitioner, who submits that this
There is
civil
no
rev-
surviving cause of action.
this civil revision petition has become infructuous as there is no surviving cause of action. Considering the submissions made by learned counsel for the petitioner, this revision petition is dismissed on becoming infructuous.
Obliged.
May it please, Lordship.
Yes,
Lordship, we are on behalf of appellant IOCL. IOCL provide us yesterday name of the deceased legal heirs of the respondent, so require 2 weeks time, Lordship, to file appropriate application for substitution
heard Miss
and Dr.
M. Datta, learned counsel for the applicant, who submits that IOCL, the Indian Oil Corporation Limited, has been furnished with the names of the legal heirs of
Legal heirs of respondent number 1, 4, and 5.
1, 4, and 5 only yesterday, and therefore some time is prayed for taking appropriate steps in this regards. The prayer is allowed. Let this matter be listed after
2 weeks.
after 2 weeks.
I do applies.
None appears for the applicant on call. on perusal of the record, it appears that on the last occasion also, on last two occasions also, the applicants were not represented by anyone. And it was specifically mentioned in the order dated 19/6/2024 that if no one appears today, the instant interlocutory application would be dismissed for non-prosecution. Hence, this court is constrained to dismiss the instant interlocutory application for non-prosecution.
Application 24. Application 23.
In this case, my lord, I have been appointed as amicus curiae, my lord, here. What is happened actually, my lord, mandatory injunction on title suit was filed, my lord, by the petitioner, my lord. Thereafter, my lord, it was dismissed for default, my lord. That is page, kindly peruse your lordship. That order is at, my lord, page 27.
No, before you start,
Yes, my lord.
whether the notices to other notices are duly served.
Notices, my lord. Notices to respondent could not be issued in 19/7/24 there, as it has been learned from the previous honorable court's order dated 18/11/19 that respondent number 1 died. List on 26/7/24.
Respondent died.
Yes.
And petitioner,
So for petitioner is concerned, my lord, learned counsel who was conducting the case, he did not appear, my lord. Because
Okay.
possibly, my lord, as main case has been already disposed of, as it is seen in the, my lord, I have seen the records, my lord, in the
okay,
mobile.
now tell me what happened.
Yes, my lord. It was dismissed for default. Restoration petition filed by
Title
the
suit,
lordship.
title suit
Yes, my lord.
for,
For my due to non-appearance of the learned
no,
counsel.
what was the relief sought for in title?
A relief sought for, my lord, and order 9, rule 7 petition was also filed, my lord.
No.
Oh,
For
yes.
what title suit was
Yes,
filed?
my lord, mandatory injunction, my lord,
Okay,
for
okay.
road.
Thereafter, this was dismissed on
Default, because the plaintiff itself, they himself appeared, cross-examination also done, my lord. As it is reflected in the petition, they have filed, my lord. Order 9, rule 7 petition is at page, my lord, 24, annex 4.
Thereafter,
Thereafter, this petition, when this petition was filed, my lord, opposite party also objected. Written objection was there from the other side, my lord, opposite party. And accordingly, learned, my lord, trial court below, my lord, page 35, their petition, mid-J case was, my lord, their prayer was rejected. It was ordered on 18/1/14. This petition was rejected.
no, you are not presenting it properly. Every title suit was filed.
Yes, my lord.
Title suit number 47/2005.
Yes, my lord.
When it was dismissed,
It was dismissed on, my lord, 21/3/11.
21/3/2011.
11. Page
Dismissed for
27.
default. Thereafter, what happened?
Thereafter, my
What
lord,
restoration petition was filed?
yes, restoration petition filed. It was filed, my lord. That mid-J number, this is a number 25/11. Annexure 4, page 29.
Okay. What happened?
Yes, and it is also evident in the order itself, my lord. Page 27. Page 27. 24/11 possibly it was filed. Yes, record is put up before me. Seen the petition for 11/11 by the plaintiff under order 9, rule 7, with section 151 of the CPC, a miscellaneous case be registered in view of the petition given today. The present case record be put up on disposal of the missed case. This petition is J number 2511, page 29, Annex 4.
Okay. Thereafter,
Thereafter, opposite party, my lord, defendant, as a opposite party file objection, my lord, page
against restoration petition.
against the restoration.
Okay.
Annex 5, page 33.
Thereafter,
Thereafter, this order has been passed, my lord, 18-114, page 35. Lanet Munship number 1, Nogao,
this is, it rejected the prayer.
rejected the prayer.
Against that rejection order, you have approached this court.
Against this rejection order, miss appeal was filed. Order against order, miss appeal was filed.
Okay.
Before the Lanet Civil Judge, Nogao. That
This,
miss appeal is Annexure 7, page 36.
no, this dismissal order is 18.
Dismissal order is 18-114.
Against this order.
Appeal filed under order 43,
Okay.
Annexure 7, page 36. Being highly aggrieved and dissatisfied with the order dated 18-114 passed by the Lanet Munship number 1.
Thereafter,
Thereafter, judgment delivered affirming the said dismissal order, my lord.
no interference.
Yes, my lord, not interfere. That is
Which
page
is the order?
41.
Page 41. Against that,
Against that,
this civil division has
Yes.
been. Now, what is your submission?
my submission is that, my lord, I have checked out the records in the mobile, my lord. There is nowadays it is a status. This status I have seen title suit 4705. Dispose of, it is seen to be shown to be disposed of on 13-10-11 itself. 13-10-11 by the Lanet Civil Judge Junior Division number 1, come JMFC. But that order is not online here.
13, 10, 11,
13-10-11.
but it was dismissed for default.
No, yes. Otherwise,
On
it was
21,
21-3-11. Yes.
Then how it can be
I don't
disposed?
know whether records on it in the mobile
Well,
phone. Whether
No, records are there.
Oh, yes. The records, if records are there, then
You go through the records. Record আছে নে? Trial court record. নাই।
beyond in the mid bill in the my lord, bottom line, one order was passed after the reject this my lord, order 9 rule 7 petition was dismissed by the Lanet Munship.
No, when all the restoration petitions are dismissed,
Dismissed.
how it can be restored? And how it can be again disposed of on 13-10-11?
Yes.
When the record shows that on 21-3-2011, it was dismissed for default.
Default.
Then unless it is restored,
Restored.
no order can be passed
Passed,
on
yes, my lord.
13-10-11. So what is your submission? We'll call for the record,
Yes, my lord. That will be written.
then we'll examine
Yes.
it. Third, Mr. H. Das, learned counsel for the learned amicus curiae who has been appointed by this court by order dated 25-2024. During course of hearing, it appeared to this court that the learned amicus curiae, as learned amicus curiae has submitted that from the CIS
Yes.
of E-Court.
Hmm.
It reflect, it is found that the title suit number 47/25 has been disposed of on 13/10/2021, 2011. Whereas from records, it appears that on 21/3/2011, the said suit was dismissed for default,
Default.
and there is no record of its restoration.
Yes.
Therefore, comma, perusal of the case record of title suit number 47/04 is felt necessary for consideration of the instant civil revision petition. Hence, call for the record of title suit number 47/05 from the Court of Learned Munsif number 1, Nagaon. The registry to take steps for requisitioning the aforesaid case record. Let this case be listed after 4 weeks,
Obviously.
after receipt of the trial court records.
Obviously.
May I please, Lordship, extension of times require my lord to file affidavit with paper, my lord, newspaper.
Third, Miss, what is your name?
L. Sharma.
L. Sharma, learned counsel for the applicant.
Appellant, insurance.
Applicant insurance. This miscellaneous case is for condonation of delay.
Yes, my lord. Restoration, my lord.
Restoration.
Restoration.
Yes, your lordship.
Also heard Mr.
S. Paul, your lordship, for respondent number 1.
S. Paul for respondent number 1. Learned counsel for the applicant has submitted that though this court directed the applicant to take steps for issuance of notice through paper publication on respondent number 2. The applicant could not take the requisite steps. Hence, some more time is
Needed, my lord.
required for
Step, we have taken steps, my lord, on 27/2/2024, my lord. White memo number SC.
now, what is your prayer?
My lord, we have to file affidavit with
Affidavit,
paper,
no,
my lord,
okay.
paper publication.
It's a line to continue. Though the applicant has taken steps in pursuant to the directions of this court by order dated 26/6/2024. However, some more time is required to file an affidavit of compliance. The prayer is allowed. Let this matter be listed after 2 weeks.
Obligation.
Oblige, your lordship.
Pleases your lordship. Lordship, here the service is complete and LCR has come, so it can go for final hearing, lordship.
Heard Mr. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. S. Dutta, learned counsel for
Respondent 8,
respondent
United
number
India
8,
Insurance.
as well as Mr. A.T. Sarkar
For respondent number 1, 2, and 3.
for respondent number 1, 2, and 3. It appears that the service on all the respondents is service of notice on all the respondents is complete, and the records of the concerned MAC case has been received from the concerned tribunal. Hence, this case is ready for hearing. Registry to list this case for hearing on a date to be fixed by registry.
Lordship, date may be fixed by this court, lordship, because accident occurred in the year 2015, lordship. Kindly allow me to submit.
When do you
Another
want?
day,
When do you want?
They filed appeal.
No, when do you want?
Any date maybe. Next
Date
month
I
maybe.
cannot fix. I can fix week. In the third week of August. On a date to be fixed by registry.
Obliged, Lordship. Lordship, 31 services complete, Lordship. Otherwise, this is a delay petition, Lordship. Service is complete because in the last that we had filed the additional affidavit to show newspaper publication. Otherwise, this is a delay petition, Lordship. Delay of 104 days, Lordship.
No, there is.
As per Lajima order, Lordship, service report on 2 is complete. And we were directed to take on by order dated 22-24. Thus the service on respondent number 1. So we had filed the affidavit, Lordship.
Where?
It's,
Affidavit on respondent number 1.
yes, Lordship.
Okay.
Service, his signature and his phone number received by Rafiqul Islam on behalf of Sattar Ali and both the phone
Miss
numbers.
R.D. Majumdar, learned counsel for the applicant. It appears that the notice, how many respondents are there?
2, Lordship.
The notice issued to respondent number 2 was already duly served. And the respondent and the applicant was directed to take steps for issuance of notice on respondent number 1 through Dusty mode. Learned counsel for the applicant has submitted that in pursuant to the directions of this court, the applicant has taken steps and has taken steps accordingly and has effected the service of notice on respondent number 1 through Dusty mode. And in compliance of the said, an additional affidavit has been filed by the applicant, accompanied by the copy of notice, wherein the signatures of respondent number 2,
No,
respondent number 1 is appended. Considering the affidavit of compliance filed by the applicant, it is hereby held that the notice on respondent number 1 is duly served. Now what?
Lordship, delay 104 days. That,
What was the date of appearance in the notice?
that 3 weeks, Lordship.
So we have to again fix it or
Okay.
he may appear. No fixed date was given. We'll fix it for in orders column it's
Yes, because the IA, Lordship.
okay. The notices on all the respondents are, both the respondents are duly served. Hence, some time may be granted to them so that they may appear in this interlocutory application. Let this interlocutory application be listed again on
Next week, Lordship.
next week.
A date may be given, Lordship, because this is IA only. It will come for orders on
On 7th,
7th. Fine, Lordship.
on 7th August 2024.
Highly obliged, Lordship.
I have no respondent number 1, 4, and 5.
Who is for the
Ma'am, it is
third, Mr.
G Pathak.
D. D. Pathak,
Z Pathak.
G. Pathak, appearing for respondent number 1, 4, and 5. None appears for the, this is for condonation of delay.
Oh, no, no, I have to file affidavit.
You will object.
For
None,
next time may be granted.
none appears for the applicant on call. Learned counsel for the respondent has prayed for some more time for filing written objection against the prayer made by the applicants. Prayer is allowed. Let this matter be listed after 4 weeks.
Yes, sir.
May I please have a look? In the IA, the office note that 23/2024 also kindly clear this. Service is not complete upon us. Executed respondent number 2, A, B, C, and D.
I number 3841.
Yes. Sir. It's not dated 20/3/2024.
Your Lordship, I'm appearing for respondent number 1, 2, and 3. Oh, 2 expired.
2 expired only.
You are appearing for 2 A, B, C, D. All
Yes.
legal, 2 also.
Uh, 2 A, B, C.
You are appearing.
Yes, Your Lordship.
Okay. And other respondents, respondent number,
Not Your Lordship.
Also 4, 5, 6, 7 served. 8, 9, 10 not served. And 15, 16 not served. And others.
you have to take
Take
steps.
resolutions.
Third, Mr.
A Borwa.
A. Burwa, learned counsel for the applicant. Also heard Mr.
S. Diffusa, appearing on behalf of D.
S.
Chaudhary. S. Diffusa,
S. Diffusa,
appearing
appearing,
on behalf of D. Chaudhary.
appearing on behalf of D. Chaudhary. Learned counsel for respondent number 2 A.
1,
Learned counsel for respondent number 1,
2 A, B, C, and
2 A, 2 B, 2 C, 2 D,
and 3.
and respondent number 3. On perusal of the office note dated 23/2024, it appears that notices input to respondent number 4, 5, 6, 11, 12, 14 are duly served. Stop. However, notices issued to respondent number 7, respondent number 8, 9, 10, 15, and 16 are not served as addressee were not found. The applicant is directed to take fresh steps for issuance of notice on respondent number 8, 9, 10,
15 and 16.
15, and 16 by registered post with AD as well as by usual mode within
Weeks, Lordship.
3 days from the date of this
1
order.
week or so.
Within 1 week from the date of this order, returnable on 9th of September. List accordingly.
Like.
Kindly produce the order dated 23/7. also. Two matters has been taken.
Yes.
In the connected CRP, Lordship, service is awaited upon the respondent. Lordship.
Oh.
Yes. And here also in the FAO also, 3, 4, 5 not appearing. Service is awaited.
This is 30.
35 is FAO. Lordship. FAO is 35 and the CRP is
36.
36.
Into বেলেগকে বান্ধিব। Third, Mr. in 35. Third, Mr.
As that.
S. Deka, learned counsel for the appellants. Also heard Mr.
MM Bhuya on behalf of Iqbal for respondent 1 and 2.
M.L. Bhuya, appearing on behalf of Mr. A. Iqbal, learned counsel for respondent number 1 and 2. Learned counsel for office note is there. Who are 3, 4 and 5?
This is my vendor. Lordship.
What is their name?
Lordship.
Names?
Monomoti Gogoi, Sandeep Gogoi and Sanju Gogoi. Legal hair of my vendor.
Because AD card has been received back with signatures of Monomati Gogoi.
Then service is complete, Lordship. They are not appearing. Keep the matter pending, otherwise they may come with a implement in this FAO, Lordship. Because subsequently they are transposed, defendant number 7 and 9 in the CRP, which we have challenged in the CRP.
In CRP, these 3 are also parties, Monomati.
No. In the CRP, only this in transposition defendants are party.
Okay. It appears from the office note dated 4/6/2024 that the AD card of the notices sent to respondent number 3, 4 and 5 are received back with signatures of Monomati Gogoi within bracket respondent number 3 on all the AD cards. As the in view of above, the notices sent to respondent number 3, 4 and 5 are held to be duly served. It appears from record that by order dated 23/7/2024, this FAO was tagged with CRP within bracket IO number 2110/2024. And in the said CRP, the services on the respondents are yet to complete. Hence, let this matter be, when you want,
After 4 weeks.
let this matter be listed along with the said CRP after 4 weeks. In item number 36 in the CRP, heard Mr. S. Deka, learned counsel for the, here who is the petitioner?
Petitioner is defend this in the respondent who has not appeared. Two of the respondent here petitioner along with the appellants. This Monomoti Gogoi is also the petitioner. Defendant number 1, 2, 3, and 5 to the suit.
Who is for Amit?
Omid is the petitioner, Omid Ankit,
Ankit, who is appearing
and we are appeared.
for Amit?
Yes, in FAU, Omid and Ankit are the appellant. This Monomoti and Sarju Gogoi, they were the pro forma respondent. But here they have joined with us.
Here they are the petitioners.
Yes,
So you are for petitioners?
petitioners.
Learned, S. Datto, learned counsel
S.
for
Deka.
the, S. Deka, learned counsel for the petitioner. And none has, you are not appearing.
No.
None has a. No, it appears that the notices sent to respondent number 1 to 4 are not yet returned back. What will you do? Await or take fresh?
Await on the 24/7 office also.
Await further. Let this matter be listed again after 4 weeks, along with FAO case number 22/2024.
Interim to continue.
The interim order, where interim order?
In the CRP, there is.
In
interim.
CRP, there was an interim. Earlier,
Yeah.
interim order shall continue till next day.
Obliged.
May I please? Your Lordship, what happened, Your Lordship? The petitioner is the Bazaar Committee, Your Lordship. And let me finish. Huh? Take one and
Milord, I am for the all respondents, Milord. Yesterday, we filed objection and
It is not yet time.
yes, Milord. So let me be fixed for hearing. It is not with the record.
Your Lordship, I just giving your Lord a background of the case here.
No, not today. And when
Actually-
the matter is come,
Actually.
we are
the-
fixing it for,
Milord, interim was there, but till returnable date, so let me be fixed.
It has been continued. And
the service is complete.
Yes, Milord.
service complete. Some interim order has been, protection order has been passed for which they have not complied. And for that, we have also filed a contempt. That contempt notice has been issued. They have violated the order.
The contempt is
Yes,
listed separately.
separately.
Today it is not listed.
No. Contempt has been listed and notice has been issued for violation of the order.
Which order?
29/7/2022, contempt case 389/2024.
Violation of which order?
Violation of the order dated, Your Lordship.
In this case,
Yes, in this case, Your Lordship,
8/5/24,
yes. The order was that
8, no
It is-
construction.
further directed that till the returnable date, no construction work shall be undertaken over the schedule E to M land.
Okay, heard Mr.
Armadillo.
R. Majumdar, learned counsel for the appellant. Also heard Mr. S. Sinha, learned counsel for the respondents, who submits that the respondent side has already submitted a written objection in affidavit,
We'll file our reply, Your Lordship.
which has not been tagged with the case record, and praised for bringing the same on record. The registry is directed to list this matter again. When do you want?
But it would be on 16, it would be better. 16.
No, I will require 2 weeks time to file my reply.
Okay. list it again after 2 weeks. With that contempt, can it be listed?
Yes, yeah, it should be.
Contempt,
Yes, it should be listed
It should be, yes.
together.
I will not get that notice.
that can be listed, your
Then
lordship.
they will accept notice in that
Yes.
contempt.
Notice has already been,
What is the case number?
case number, contempt case number 389,
List it together with, list this case together with
389,
contempt case number 389
2024.
of 2024. Learned counsel for the appellant has submitted that. No, what reply?
Against their objection.
That they may be allowed to file reply to the objection filed by the respondent side. The prayer is allowed. The petitioner may, appellant may file its reply before the next date fixed. List this matter accordingly after 2 weeks.
Did we fix me that on 13,
Let this matter be listed
16 or
16.
16?
16.
in the 3rd week of August on a date fixed to be fixed by registry.
Third week.
3rd week of August on a date to be fixed by registry.
Not one, another, humble submission. The scheduled photographs, Milord, they have annexed and supplied to us.
Not clear.
It's not clear. So we cannot compare that these schedules lands are,
No,
our land.
we have annexed.
No,
Whatever is in the title suit, that title suit already they have received notice.
no, Milord.
I have
Appellant
annexed-
submitted clear photographs before the court. And why not? I will go through that clear photographs so that I can compare with the
Clear.
schedules.
Give him clear photograph.
Yes, Your
Otherwise,
Lordship. Nothing, Milord,
it will go against you.
nothing, Milord. It's only black square.
Which page?
আপনি sir. কি ধরে পড়ি?
Furnish him legible photographs.
Already they have furnished in that suit. Suit they have received. In the suit, your lordship, they have received all annexes, same set,
No, you,
We see
same
that.
set of
See the
advocates.
court file.
what
not-
photographs? You furnish legible
Yes,
photographs.
Yes.
He will furnish.
Page number.
No, Milord. They filed the Milord, this instant appeal, Milord. How can they, Milord, produce all the photographs, Milord?
There is
They
nothing.
brought all the photographs on record, Milord.
In this case, they have
Yes,
filed.
Milord, yes. Milord.
Where?
They
Along with my plaint. Along with my plaint.
Learned counsel for the respondent has submitted that
Page 218, Milord.
the
282 lage.
218
The-
onwards, all the schedules.
Good.
Oh my God.
the photo, yes, you have filed legible photographs in the court.
Yes, at least not color, but black and white.
You have to file same photographs.
Yes.
Give a copy same to the
Respondent.
respondent. Otherwise, how they will prepare their objection?
They are already having a set in
No.
title suit, same set of advocates.
No, that plea you cannot take here.
Even then, I will
You fund-
supply. On page.
क्या लिखा? Sharmila
All schedules.
Schedule.
submitted that The-
The.
appellant has not furnished legible copies of the photographs which were annexed to the plaint. Stop.
Oh,
And
page-
hence, from page
Two.
218 to 229,
29. Yes.
hence it becomes difficult for him to prepare, to go through the same and prepare the objection.
Already they have prepared and filed it. They have served the copy.
The petitioner is directed, the appellant is directed to furnish legible copies of photographs to the respondent side before the next date fix, list accordingly.
This period they should have made in the last date because they have already filed it.
Now you furnish.
They will again file. Oblige.
Malat, kindly peruse the order dated 27/6/2024.
Your lordship, one thing, your lordship. There is an interim order operating, they will continue.
Interim order shall continue till next. Year. Yes, what is this?
My lord, by this order, I was supposed to take the dusty service. The service has taken. And I think my learned friend has appeared already on behalf of the respondents.
Okay,
So
service is complete.
service is complete. And my lord, I
Will-
pray for a date because the interim order is not operating. So this honorable court expressed the view in earlier occasion that the matter supposed to be disposed of. The matter regarding non-acceptance of the written statement filed by the petitioner, who are the defendant in the suit matter. What had happened?
Okay. We are fixing it for admission hearing.
Yes.
Yeah.
No,
Heard
that
me-
day, my lord, the endeavor may be,
Heard Mr. R. Islam, learned counsel for the petitioners. Also heard Miss, what is your name?
Dina Sarkar.
L. Sarkar.
L.
L. Sarkar, who is appearing for, how many respondents are there?
3 respondents.
All respond.
All.
The respondents. As the services on the respondents is complete, as service of notice on respondent is complete, let this matter be listed for admission hearing. On when do you want?
Any date, my lord, after 1 week. 12 or 13, well, 13. How about this?
On 13 August 2024.
Much.
My lord, we have taken step upon respondent number 1 to 4 on 23rd of July. And the report for respondent is still awaited.
No, you have to take fresh steps.
We have to take fresh step upon the.
Yes, because say notices were returnable on 26 July. And you took steps on 23rd July. Within 3 days, how notices will go in? You have to take steps within the time prescribed by, the time was,
Lordship, vacation was already started and the party did not appear.
heard Miss
Error.
K. Roy, learned counsel for the petitioner. It appears from record, it appears from office note that the steps for issuance of notice on respondent number 1 to 4 was taken by the petitioner side on 23rd July 2024, whereas the notices were returnable on 26/7/2024. In view of above, in view of this, and the no service report has been received back yet, stop. The petitioner is directed to take fresh steps for issuance of notice on respondent number 1 to 4 by registered post with AD within how many days you will take steps? Within 1 week from the date of this order, returnable on 13th of September 2024. List accordingly. What is this?
But see, it is a high. And what I found from the cost title part, Lordship, is the page 1. The application is filed under 528 of the BNSS, read with section 482 of CRPC. Lordship, earlier there was an order passed by this honorable court, Lordship, with a direction whenever disposing the AB.
Disposing, acha.
Yes, that is disposed of. Later, they have, in that particular order, Lordship, page number 43, Lordship.
Yes,
Yes, Lordship, last two para. May I read it out, Lordship?
yes.
Learned counsel for the petitioner has submitted that the trial court has yet to issue any process against the present petitioner. However, as the name of the petitioner has been shown as an absconder, he is apprehending that he may be arrested in connection with the case. So this is the line. And the next para, Lordship, learned additional public prosecutor on the other hand has submitted that as the trial court has yet to issue process, there is presently no basis of apprehension of the arrest by the arrested petitioner. And now, Lordship, next page number 44, Lordship.
Yes.
Lordship, the trial court, only the relevant part from the second line, the trial court is yet to issue any process against the present petitioner. This court is of the considered opinion that this anticipatory bail application may be disposed of with a direction to the petitioner that he shall appear before the trial court within 15 days of this order and may pray for regular bail before the said court, and in the event of filing such an application, the trial court shall consider the same in accordance with law. So that was the direction passed by this honorable court. Now, Lordship, this application IA is filed for the modification of the order. Now, what I have found from the prayer portion of the IA, it is stated that at that particular point of time, when the order was passed by this honorable court, NBWA was issued, but that was not placed somehow for some reasons. For that reasons, against that particular NBWA, Lordship, this IA is filed, Lordship. And before that, Lordship, one AB was filed, and that was also withdrawn. They have stated that part. But the later part I didn't find, Lordship, it is page number 6, para 7.
Now, the petitioner is not present. What is to be done?
Lordship, whether this I and
Is maintained.
without hearing petitioner, I think, Lordship, that is also not.
Okay. None heard Mr. K. Basho, learned additional public prosecutor. None appears for the petitioner on call. Let this matter be listed again on Monday, on 5th of August.
Lords.
Please, Lord. Notice has been served, Lord. I is for condonation of delay, Lord. So what had happened in the year 1996?
From where you are saying notice have been served?
It's reflected in the office note, Lord. But if the case is that in the year 1996, some land was.
You are appearing for?
I'm appealing for the state also.
It's a performer responder.
My lord, only thing, the first thing, my lord, I would like to point out, before wasting the court's time, the condonation delay is for more than almost 6,000 days, my lord. That means it is so long that the only thing is that they were not made a party. But then did they take the things that they have to do? They should have inquired also, no? There was a duty on their part also. And they are trying to put the blame on our head. We are the state, my lord. There are so many cases in our. It is not possible to take so much interest in one case.
No, let us hear him.
Lordship, in the year 1996, some land around 63 acres was acquired to LA case number 9/93.
No, what happened in 1996?
1996, land measuring around 63.
Who is the respondent number one?
Respondent number one is one of the Habib Ali. He is one of the partners from whom we
You
have
are
acquired the land.
Indian Oil Corporation.
I'm Indian Corporation. Well, for our requirement, land was acquired. What has happened, then they came for section 18. Section 18 reference was there. In the reference case, they have not made as a party. After the reference case, they have filed an execution case. In the execution case, notice was issued to the performer respondent. When performer respondents got the notice, they sent it to us in the year 2023. In April 22. It is only then we came to know that the case is pending. Thereafter, we applied for certified copy. And in one court, what happened, in the execution court, they told us that our original record is not with us. Therefore, you go to another court, ADJ 3, where we have thereafter applied for certified copy. In December, we had applied for certified copy.
Now, what happened in land acquisition case?
LA case, the award was enhanced.
How much from?
It was enhanced from 16,000 per katha to 70,000 per katha.
But it was contested by the government.
It was contested
we
by the
had a-
government. We were not made a party. Thereafter, they have filed an execution. Execution was filed lately. Execution case in 2020, they have filed an execution case. After receipt of notice, the deputy commissioner has sent us a letter. Then only we came to know in the year 2022. It is only then we came to know that the LA case is pending.
There was a money execution case in 2020. So we had written that letter to inform them that this case is there, so you have to deposit the amount.
When you have informed?
It is from 2022. 1st of April 22. Letter is dated 1/4/2022. We have received it on 4th of April.
Then what happened from one?
Thereafter, we have applied for certified copy of the judgment. In the executing court, when we applied for certified copy, the executing court, after 2-3 months, they told us that the record, original record is not with us. We cannot provide certified copy from certified copy. That's why they directed us to apply for certified copy in another court. Then we applied for certified copy there also. What happened, Lordship? There also they could not trace the record. Since they could not trace the record, having no other alternative, I appraised the district judge. Lordship will kindly have a look at page 26.
Yes.
I have brought to the district and session judge regarding.
When have you applied for certified copy?
First, we have applied on. In April itself, we have applied on.
When, which date?
April, Lordship, date, Lordship.
Because dates are relevant.
Huh? On July 22, we have applied. Lordship. July 22, we have applied for certificate.
Why this delay for 3 months?
There was a delay, there was some communication between us. communication between IOC and the performer respondent. We have tried to inform it in the executing court.
Ultimately, when the certified copy was furnished to you?
Certificate copy, in fact, has not been furnished till date.
Okay.
The Lordship may kindly have a look at paragraph 26 or page 26. first. Yeah, I have made a complaint before the district and session judge regarding the non-furnishing of the certified copy. But till date,
Certified
we
copy of the,
of the judgment and decree dated 30/10/2008. Lordship. Passed in misreference case number 10/2002. There are two cases, 205 of 2001 also. In those two cases, execution has been filed. This case belongs to.
now what was the reply of the district judge to your letter? What were you informed?
No information was given. They have only received a copy. No contract has been made till date.
Mr. Bhattacharya, what is your submission?
My submission is that my lord will see the human, from the human angle, my lord. Now, whatever, they are not made a party, that is a fact, that I'm not contesting. But even after the enhancement, it is true that it was enhanced from 16,000 to 70,000 per katha. That means 70,000 into 5, 3.5 and a half per bigha. That was 80,000 per bigha before us, when the district, when the collector had passed the original order. So if after that, there was a reference case. So in the reference case, this enhancement was allowed.
70.
Yes, in 2008. Now, suppose I agree with them, at that time, it was exorbitant for them. But after that, 16 years has passed.
Till now, no.
Till now, they have not been paid they have been paid the original 16,000 per katha that we had given them, the deputy collector. That they have been paid. They have filed this appeal under protest, the reference case under protest. The landowner.
They have paid at the rate of 16,000.
16,000 per katha. That is
enhanced portion they have not yet.
They had not been paid.
But
and now after the enhancement.
What has happened to execution case?
So money decree that after that they have filed this appeal, it must have been stayed, my lord.
No. Not so. In fact, as per my knowledge, Deputy Commissioner has made the payment.
At the enhanced rate.
I think so, but the other side is not here today. Deputy Commissioner has paid it. But we
And
could
has
not-
satisfied the judgment of
Yes,
LA
yes,
case.
Yes,
Now you have to pay it to the government.
yes. The problem is that we were not made a party there. Now, without being made a party, we cannot release such a huge amount.
Now.
Okay, I'm
Then,
condoning.
my lord, and the delay is 5,070 days.
No,
And
4,792.
then after.
4,719 is
No,
completed.
my lord will come to their prayer, my lord.
Have you filed any objection?
No, my lord.
File a proper objection if you want.
At page 10, my lord, the order.
No, Mr. Bhattacharya, today we'll declare the service to be duly complete.
Yes.
If you want to file an objection, you file an objection, or we condone their delay.
And if the private party appears, my lord, on the next day. So
Okay.
let them complete that is very important because the private party.
They have received
Because-
notice and they have
Because
submitted-
if they have received
No, they
the.
are not, if they got the money,
Right.
they
They
may
will
not
not
be
come.
interested. They will not come.
But that
It
is
is-
why.
it is the
it
government
proper
only.
My lord, I agree with my lord. It's proper to wait for one more day
Okay.
for them. Because
Uh,
if they have been paid the 70,000 per katha, that is a relevant fact.
Okay. Heard Mr. M. Gogoi, learned counsel for the applicant. Also heard Mr. K. Bhattacharya, learned. Your government,
Yes, I am for the state of Assam, my lord.
Then-
Respondent two.
you are government advocate.
Yes.
Government advocate appearing for respondent number 2. On perusal of the order dated 18/7/2024 passed by Lawazima Court, it appears that the service of notice issued to respondent number 2 is duly complete. Hence, duly complete, stop. The learned government advocate submits that he may be allowed some time so as to take necessary instructions whether to file any objection against the application filed by the applicant or not. The prayer is allowed. So let this case be listed again.
Approximately fix a thought that because
Yes.
in the deputy commissioner has issued an
On 13,
Pakizai proceeding has been initiated there against us.
on 13, no, you have to pay unless,
No, we will
okay.
pay
On 13/8/2024.
Okay.
13 is okay or?
Because what he has said is something very serious, my lord. Because I came to aware for now only that we have paid them amount.
Yes.
So that will be between them and us then.
Yes, therefore
Something has to
you may have to file
I have to
No.
find it out, my lord. Yes.
13/8,
They had received notice long back.
13/8.
May I please, your lordship? Lordship, he should have preferred the appeal before the district judge, my lord. Because the is against an amount of rupees 19 lakhs and odd. They to execution jurisdiction lies up to 20 lakhs before the district judge.
Oh,
So he should have preferred
this,
here.
this interlocutor application is for
For
condonation.
condemnation of below, my lord. But he has exceeded the
fix it on Friday.
exceeded the jurisdiction, my lord, because it's
But even if the delay is condoned.
No, Lordship. I will just spare us the notification regarding the.
Okay,
notification I have.
okay, let him go through. We are fixing it on Friday.
Yes, Lordship, will kindly fix it on Friday.
You make your he may
Yes, yes.
withdraw.
Yes. If he is,
If you agree with the notification,
yes, I will have
instead
to
of
approve the.
pressing your interlocutor application,
Lordship.
you may file again a fresh condonation petition before the district judge's court.
Then Lordship may kindly take care of that. Also.
Heard Mr. R. Bora, learned counsel for the applicants. Also heard Mr.
Uses like, yeah.
U.J. Soikia, learned counsel appearing for
They sole response.
the sole respondent. Learned counsel for the applicant has prayed that this matter may be listed again, that some time may be granted to him for going through the relevant pecuniary jurisdiction of court in this regard, in connection with this instant regular first appeal. The prayer is allowed. Let this matter be listed again on 2nd August 2024.
Always, Lordship.
Wait, please, Your Lordship. This interlocutory application has been filed under Section 5 of the Limitation Act for condoning the delay of 5 days, Your Lordship.
5 days.
Yes.
You are contesting.
No, sir. I don't have any
Conceding.
objection. Yes, Lordship. 5 days only.
Miss, what is your name?
S. Jain Sanjukta Jain.
S. Jain, learned counsel for the applicant. Also heard Mr.
A. Burwa.
A. Burwa, learned counsel for the sole respondent. This application under Section 5 of the Limitation Act has been filed by the applicant for condoning the delay of 5 days in filing the connected first appeal, wherein the applicant has impugned the order dated 29/1/2024 passed by the learned additional district judge Jorhat in which case?
In Miss G case number 44 of 2023.
In Ms. J case number 44/2023. So, learned counsel for the respondent, learned counsel for the opposite party has submitted that as the delay sought to be condoned is only of 5 days. He has no objection if the delay is condoned by this court. Considering the submissions made by the counsel for respondent, as well as considering the reasons for delay mentioned in paragraph number 2 of the delay condonation petition, this court is of considered opinion that the applicant has sufficiently explained, applicant has shown sufficient cause for filing the connected matrimonial appeal delayedly in this court. Hence, the delay of 5 days in filing the connected matrimonial appeal is hereby condoned. And this interlocutory application is disposed of. Registry to register the connected matrimonial appeal and list the same in the next week on a date to be fixed by registry.
It's in my humble praise that our name may be shown while the
Okay,
appeal.
okay,
This
okay.
thing. We have filed the wakalatnama in the I.
Learned counsel for the opposite party submits that the names of that his name may be shown when the connected appeal shown in the cause list at the time of listing of the connected appeal as the opposite party has already filed wakalatnama engaging him for this matter. List accordingly in the next week.
Public.
May it please the Lordship. Lordship, the appellant, she is the defendant in the suit. She filed a statement as well as counterclaim. Now the appeal, second appeal, Lordship, is a substantial question of law has already been framed. It is admitted for hearing. In the meantime,
You are the appellant.
appellant, defendant in the suit, here is a appellant.
Appellant, okay.
Second, in the second appeal. The second appeal, already substantial question of law has been framed and it is admitted for hearing. In the meantime, Lordship, the sole appellant, she died.
Appellant, right?
Sole appellant died.
Okay.
So, while filing the application for substitution, there are 137 days delay. So delay condonation application, then setting aside abatement and substitution application is pending. Now, while issuing notice in connection with the delay condonation application, from the office note, it came to the light that pro forma respondent number 8 and 9 already expired. Though the services complete on 10 and 11 pro forma respondent, they did not appear. Therefore, to exempt the substitution, I have filed this case IAS Civil 1656 for exemption for substitution under order provided under order 22 rule 44. Now, Lordship, here order 22 rule 4 provides
Read.
if Lordship the defendant doesn't file a written statement or he files written statement but doesn't proceed with the case, if court is satisfied, then in the event of death, his substitution can be exempted. Here in this case, if your lordship takes up this IA, before the decree has been passed in the title, so they both these 8 and 9 died, and plaintiff did not substituted them. And here in the case, lordship,
You are also the defendant in the main suit.
there is a sole plaintiff in the suit, and I am the main defendant, and the rest are government and all are the other defendants.
And in that, defendant number 8 and 9 died.
8 and 9 that during the pendency of the suit, before passing the decree in the trial court.
And there they didn't file the written
They-
statement.
And
Neither they were substituted
that is what you know. And it was fixed ex parte during
against
that time.
both of them.
Yes. But interestingly, lordship, after even they died, they have filed a written statement against the counterclaim. They did
Your
not-
count, your
Yeah,
count.
my counterclaim. They did not contest the suit, did not file a written statement, because your lordship knows the counterclaim is against the plaintiff. They are my co-defendant. Co-defendant need not file any written statement in the counterclaim. Had there any claim, then first they have to file written statement in the main suit. Whatever may be that merit, I'm not going on to those merits. Now, this position satisfies the requirements of Order 22 Rule 4, Sub Rule 4. That is why lordship kindly see my petition at page 9, para 3. Para 3, I have stated how I come to know about their death.
Just a minute.
Page 9, lordship.
Who are the opposite party in this interlocutory application?
Main party is the respondent number 1.
And rest is government.
Rest is government.
Okay.
Regarding right title interest and
Yes.
some compensation is there.
Para?
Para 3 at page 9.
Yes.
The pro forma respondent number 8, 9, 10, and 11 did not appear in the said second appeal, in the present appeal. However, on notice given being served in connection with IA number 235 of 230, it has come to the notice of the applicants from the office note dated 5/6/23 that pro forma opposite party number 8 so and so expired on 24/11/10 and pro forma opposite party number 9 so and so expired on 16/10/11. Though the notice was duly served upon the pro forma opposite parties number 10 and 11, they did not appear in the instant proceeding. The case record reveals that suit was decreed in favor of the plaintiff, opposite party number 1, by judgment and decree dated 28/5/13. During the trial, the plaintiff did not substitute the legal heirs of pro forma defendant number 8 and pro forma defendant number 9. The suit proceeded ex parte against the pro forma defendants 8, 9, 10, 11, had order dated 16/11/09 of the trial court. Without vacating the said ex parte order, the pro forma defendants number 8, 9, 10, 11 on 30/4/10 filed written statement jointly against the counterclaim of the principal defendant number 1. However, it is pertinent to note that pro forma defendant number 9 already expired on 16/10/9 before filing the written statement. So this is the position before the trial court. Then now, lordship, this satisfies the provisions of Order 22 Rule 4. May I read the provision?
Yes.
Order 22 Rule 4, Sub Rule 4.
No, now your prayer is
To exempt
substitution of
pro forma respondent opposite party number 1, 8 and 9.
8 and 9.
Yes.
Okay.
After this, lordship, the condonation application I'm coming. In this connection, I will place to judgment, lordship, if requires. I'm having that.
Okay, read.
Lordship, then condonation also I will submit.
No. Para. Order 22, Rule 4, 4.
Yes. Order 22, Rule 44. The court, whenever it thinks fit, may exempt the plaintiff from the necessity of substituting the legal representative of any such defendant who has failed to file a written statement or who, having filed it, has failed to appear and contest the suit at the hearing. And judgment may, in such case, be pronounced against the said defendant, notwithstanding the death of such defendant, and shall have the same force and effect if it has been pronounced before death took place. Now this has to be read with, because this is, since it is an appeal, Lordship kindly see Rule 11. This rule also applies in appeal. Rule 11. Application of order to appeals. In the application of this order to appeal, so far as may be, the words plaintiff shall be held to include an appellant, the word defendant, a respondent, and the word suit, an appeal. So this exemption provision also applies in appeal.
But here, they filed a counterclaim.
I filed a counterclaim.
Nay,
Counterclaim is not against the defendant. Counterclaim is always against the plaintiff.
no, they filed a written statement against your counterclaim.
Yes,
8 and 9 filed written statement against your counterclaim.
yes. But they cannot, because my relief is not against them. Counterclaim is always against the plaintiff. They can file written statement against this plaintiff. They did not do that. Even Lordship, the second party is there, who having filed it. Suppose Lordship is counterclaim against the counterclaim, co-defendant can file a written statement. Then second person, or it is by or, who having filed it has failed to appear and contest the suit at the hearing. They did not contest after that. So both ways, Lordship, my case comes within the purview of sub rule 4.
Okay.
And
You are for?
I'm for respondent number 1, Lordship.
You have any objection?
No, Lordship.
then I'll come to the delay condonation application. Lordship.
No, suppose it is exempted.
Yes. They will remain as they are,
Okay.
because it is their Lordship. And there is a judgment also in this regard.
Who died? Defendant number?
They are not directly related to the case, because
No, in this case, the respondent number 1 died.
sole appellant died.
You also appealant.
So I filed the substitution along with the condonation and setting aside abatement case. During service of the notice regarding the condonation application, we come to know about their death.
No, but this application ought to have been heard later on, after the abatement is set aside.
No, because if Lordship has to proceed with the condonation application, so first they have to exempt it from that. Otherwise, notice will not be served.
Okay.
Or I have to submit make substitution again. So that is why first has to decide this exemption application, then condonation, Lordship, because they said they have no objection also. And it doesn't prejudice because they did not contest the case at all till this second appeal.
Okay.
So
You
by
have any objection? No. Let me pass orders in this case.
condonation is also.
Appealing for the state parties, respondents 2, 3, 4, and
In IA 1656, in IA 1656. Heard Mr. J. Deka, learned counsel for the applicant. Also heard Mr.
S.N. Ahmed, Lordship.
S.N. Ahmed,
For
learned
respondent
counsel for
number-
respondent number 1. Mr. K. Bhattacharya, appearing for learned counsel for respondent number
2, 3, 4, and 6.
2, 3, 4, and 6, and Mr. C. Borua, appearing for respondent number 5, and Miss S. Sharma, appearing for respondent number 7. Learned counsel for the this application under order 22 rule 4 within bracket 4 of the Code of Civil Procedure has been filed by the applicant
Parties are at page 5. 4 legal years.
applicant for exemption to substitute the legal representative of pro forma opposite party number 8, namely late Paskuri Ranjan Dey, and pro forma opposite party 9, namely late Adari Bala Das, respectively. Learned counsel for the applicant has submitted that the applicant has preferred connected second appeal, the predecessor in interest of the applicant. You are legal representative.
These applicants are the sons and daughters of
The predecessor in interest of the present applicant preferred the connected second appeal, namely, that is RSA 199/2014, wherein substantial question of law was formulated, as well as notices were issued to the parties. However, during the pendency of the said second appeal, the predecessor in interest of the present applicant, namely Firoza Khatun, expired, and the appeal got abated. Now the present applicant, who are the legal representative of the original second appellant, have filed substitution petition, which has been registered as
238.
interlocutory application number 238/2023 in connection with RSA 119/2014. Stop. However, in preferring the interlocutory application also, there has been a delay, and for condoning the delay, instant interlocutory application has been filed, wherein the all other opposite parties except opposite party number 8 and 9 have appeared.
10 and 11 did not appear, but the notices are on them.
Have appeared. Okay. The notices were also duly served on this opposite party number 10 and 11, who failed to appear in spite of due service of notice on them. Learned counsel for the applicant has submitted that the opposite party number 8 and 9, who were the defendant number 8 and 9 respectively in the title suit number
7/09.
title suit number 7/09, failed to file any written statement against the plaintiff of the plaintiff in the said suit. However, they did file written statement against the counterclaim filed by the predecessor and in interest of the present petitioner. Though the respondent number 8 and 9 filed the counterclaim against the filed the written statement against the counterclaim. However, they failed to contest the said case and the case proceeded ex parte against them. Hence, learned counsel for the petitioner submits that the under above circumstances, the provision of order 22 rule 4 within bracket 4 of the Code of Civil Procedure, 1908 is applicable and therefore he prays that the applicants may be exempted from substituting the legal representatives of respondent number, opposite party number 8 and 9 in this case. Stop. Learned counsel for the respondent number 1 and other respondent and other respondents does not opposes the, you also don't have any objection. Does not opposes the prayer of the applicant as what has been narrated herein before. The case of the petitioner in respect of respondent, in respect of their application under order 22 rule 4 within bracket 4 of the CPC squarely falls under the said provisions. Hence, this court is of considered opinion that this is a fit case where the above named petitioners may be exempted from the necessity of substituting the legal representatives of respondent number 8 and 9 in this case. In IA number 238.
235 is the delay confirmation.
IA number
35.
230. Two 35 or 235/2023. This interlocutory application is accordingly allowed and disposed of. Now delay condonation.
Lordship, 235 is the delay condonation application. At page 9, para 2, from para 2 I have stated the details.
This is delay condonation for substitute.
Yes. There are 137 days delay in filing the substitution petition. And in paragraph 2, I have said, Lordship, the mother of the sole defendant Firoza Khatun, she was suffering from various ailments and undergoing treatment. Then applicant number 1A, 1B, and 1C, they are unemployed youth, somehow managing their day-to-day.
You have any objection?
No.
Heard, Mr. What is your name? I forgot.
SN Ahmed.
Heard, no. Petitioner's counsel's name? J. Deka. Heard Mr. J. Deka, learned counsel for the applicant. Also same, Agor Nisna. Mr. S.N. Ahmed, Mr. K. Bhattacharya and Baki Bilakonna. This application under section 5 of the Limitation Act 1963 has been filed by the applicants who are the legal heirs of Firoza Khatun, within bracket, appellant in RSA number 199/2014 for condoning the delay of 137 days in filing the application for substitution of the appellant on her death. The counsel for the respondents have raised no objection against the said application. Stop. I have gone through the grounds shown for the delay as mentioned in paragraph number 2.
To Lordship, paragraph 8.
2 to 8 of the
As
delay
well as
conduct,
Lordship, additional affidavit also there.
2 to 8 as well as in
Additional
the
affidavit.
additional affidavit filed by the applicants. Considering the submissions made by learned counsel for the petitioner, applicant, as well as considering the grounds shown for the delay in the condonation of delay application, this court is of considered opinion that the applicants have been able to show sufficient cause for delay in preferring the substitution application. Hence, the delay of 137 days in preferring the application for substitution is hereby condoned, and this application is accordingly allowed and disposed of.
Next is Lordship, I number 236, under order 22 rule 9. In view of this delay condonation, Lordship, for setting aside a recommendation.
In I number 236, Agor Council on Name ke likhibo. This application under order 22, after how many days it has been filed? After death.
Lordship, it has been explained in para 8, Lordship, but it covers, Lordship, because the condonation application has this thing entire period, Lordship. Since delay is condoned, Lordship, this also included there, Lordship. In page 13, Lordship, will find it. There is a 90 days, Lordship, then 60 days.
60. It is within 150 days.
137 days it includes, Lordship.
Okay.
Since Lordship is condoned that delay in 235, same.
No, this petition is within 150 days of death.
Yes.
150
90
days.
and 60. 90 days for this for substitution, Lordship.
Yes.
Then till 60 days we'll get for the abatement part. After 150 days only, this abatement delay of abatement will count.
Yes.
Whereas this section 5 application, we have to file after 92 date of filing of this.
Yeah, Likha. this application under Order 22 Rule 9 of the Code of Civil Procedure, 1908 has been filed by the applicants for setting aside abatement of RSA number 199/2014 on the death of sole appellant Firoza Khatun. Learned counsel for the applicants have submitted that they are the legal representative of the appellant Firoza Khatun, who passed away on
30/12/21.
30/12/2021.
Since Lordship have a condoned delay in IO 235, this abatement also may be set aside.
Learned counsel for the applicant has submitted that the applicants had also preferred an interlocutory application which was registered as interlocutory application number 1656. No. 235/2023 for condoning the delay in preferring the substitution application for substitution of the legal representative of the deceased appellant, and same has been allowed by order dated 31/7/2024 passed by this court. On the same ground, the abatement of appeal number RSA number 199/2014 may also be set aside. And the applicants have also have sufficiently explained the reasons for which they were prevented from continuing the appeal after the death of the sole appellant. Learned counsel for respondents have raised no objections to the prayer for setting aside of the abatement of the connected regular second appeal. Considering the submission of learned counsel for the applicants, as well as considering the grounds shown in the application, which is supported by affidavit is there or not?
Yes.
Which is supported by affidavit. This court is of considered opinion that the applicants have showed sufficient reasons, sufficient cause for which they were prevented from continuing the appeal on the death of the sole appellant before it got abated by operation of law. Stop. For reasons mentioned herein above, the abatement of appeal connected regular second appeal number 199/2014 on the death of the appellant Firoza Khatun is hereby set aside.
Then Lordship, I number
And this
238
application is hereby disposed of.
238 paragraph, page 9, paragraph 2.
Heard so and so. This I number 238/23. Councils are same, all councils are same. This application under Order 22, Rule 3 of the Code of Civil Procedure 1908 has been filed by the petitioners for substitution of the legal representatives of the sole appellant Firoza Khatun, who expired on
30/12/2021,
30/12/2012.
paragraph 2, page 9.
Learned counsel for the applicant has submitted that by order dated 31/7/2023 passed in I number 236/2023, the abatement of appeal on death of the sole respondent has already been set aside. It is also submitted that the delay in filing the instant substitution application was also condoned, has also been condoned by an order by the order dated 31/7/2024 passed in I number 235.
235 delay conveyance.
235/2023.
Setting aside 236.
Yes. The applicants herein, namely Wahid Khan, Yusuf Khan, and Imran Khan, are the sons of the deceased Firoza Khatun, and the applicant Wahida Begum is the daughter of the deceased Firoza Begum Khatun. Stop. The counsel for respondents have not raised any objection to the substitution application. Stop. In view of the facts stated above, the above named applicants are allowed to be substituted as appellants
1A to 1B.
number 1A, 1B, 1C, and 1D respectively in place of the deceased appellant Firoza Khatun. Stop. The registry shall make necessary correction in the cause title by reflecting the names of newly substituted appellants in the cause title of the connected regular second appeal. This interlocutor application is accordingly disposed of. The connected regular second appeal be listed after a week, after 2 weeks, after making necessary corrections in person to this order by the registry.
Obliged, Lordship.
Yes.
This will have come up for the first time today. 188 of delay.
You are claimant.
Your
Yes,
Lordship,
sir.
I'm appealing for the claimant, respondent number 1.
It is in, appealed by insurance company.
Yes.
You will be objecting.
Objection, Your Lordship.
No objection.
Below 188 days.
Okay. Heard Mr.
As Pegu.
S. Pegu, learned counsel for the applicant, also heard Miss
AG Chaudhary.
A. D. Chaudhary.
AG.
A. G. Chaudhary, learned counsel for the
Respondent number 1.
respondent number 1
Yes, Your Lordship.
and number 2 and 3.
Nothing is.
Notice have to be issued.
Since I'm the contesting this respondent,
Their names will be struck off. Stop. Learned counsel for the applicant. You are praying for striking out their name in this IA, in
No,
this IA.
I'm paying for issue for nothing.
No, then it will get delayed. We are condoning the delay today itself and disposing of this IA. If you make a prayer for striking out the names of respondent number 2 and 3, if
struck out for me, no, no, there was necessary party.
learned counsel for the applicant has prayed for striking out the names of respondent number 2 and 3 in this interlocutory application, as the respondent number 1 is the only contesting respondent in this case. The prayer is allowed. Then the names of respondent number 2 and 3 are struck out from this interlocutory application. This application under second proviso to this application is for condoning the delay of 188 days in preferring the connected appeal by which the applicant intends to impugn the judgment and order dated 13/7/2023 passed by Motor Accident Claims Tribunal number 1, Kamrup, Guwahati, in MAC case number 2523/2017. The applicant has explained the cause of the delay in paragraph number 3 and 4 of the condonation delay application. Stop. Learned counsel for the respondent number 1 claimant submits that she has no objection if the delay in referring the connected MAC appeal is condoned by this court. Considering the submissions made by learned counsel for the respondent number 1, as well as considering the grounds shown by the applicant in paragraph number 3 and 4 of the condonation of delay application, the delay of 180, how many days?
188.
188 days in preferring the connected MAC appeal is hereby condoned, and this interlocutory application is disposed of. The registry to register the connected MAC appeal and list it again after a week.
May I please, your lordship? Lordship listed for the first time the delay application in preparing the connected appeal.
Issue notice.
Issue note.
Heard Mr. D. Mondal, learned counsel for the applicant. Issue notice to the respondents. The applicant shall take steps for issuance of notice to respondent by registered post with AD as well as by usual mode within how many days he will take steps?
1 week.
Within 1 week from date of this order, returnable on 17th September. List accordingly.
Highly obliged.
May it please your lordship. Your lordship, this matter has come up for the first time. There has been a delay of 77 days in filing the appeal.
Heard Ms. P. Thakur, learned counsel for the applicant insurance company. This application has been filed by the applicant for condoning the delay of 77 days in preferring the connected MAC appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice to the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 17th of September 2024.
Obliged.
What is this?
Lordship, it's a for condonation of delay for 145 days, Lordship. The railways tribunal against the railways tribunal's order, Lordship.
Yes.
Lordship.
Lordship, in the last date of hearing, I placed before the court 7 judgments.
No, but let him submit.
Yes.
Lordship, if he want to proceed, Lordship, he can, Lordship.
No, no.
He can, Lordship. Then you please sit down.
Sure.
You must know the.
Appeal is under what provision?
Lordship, is section 23 of the railways.
This is appeal against?
Against the Lordship, RCTS order, Railway Claims Tribunal's order, Lordship.
Read.
Section 23.
Is there any limitation prescribed there?
Lordship, no. The only 3 months is there, Lordship, but there is no express bar, Lordship.
3 months, read that provision, 3 months.
Lordship,
provision.
Lordship.
Railway Claims Tribunal.
Lordship, Lordship.
This act is, what is the name of the act?
Lordship, it says that on a Railway Claims Tribunal Act 1987. Lordship.
Railway Claims Tribunal Act.
87, Lordship.
Read section 25,
Lord, 23, Lordship.
23.
Lordship, Lordship. Lordship, professionals, then Lordship, internal page, Lordship, 72, Lordship.
No, I don't have book. You have to read loud.
Lordship, Lordship, Lordship. Book out, Lordship, note 9. Act. Railway Act 30 to lagi, Lordship.
Read it.
No. Section 23 appeals, Lordship. Safe is provided in subsection 2 and notwithstanding anything contained in the Code of Civil Procedure 1908, Lordship, or in any other law, an appeal shall lie from every order not being an interlocutory order of the Claims Tribunal to the High Court, having jurisdiction over the place where the bench is located, Lordship. Then it says that, to Lordship, no appeal shall lie from an order passed by the claims tribunal with the consent of the parties, lordship. Then it says that every appeal, lordship, every appeal under this section shall be preferred within a period of 90 days from the date of the order of the appeal against it. That is the
So
provision.
that is the limitation.
That is the limitation, but there was no express bar, lordship, regarding, lordship, non-application of the limitation act, lordship.
No, when the law itself provides limitation.
Lordship,
Limitation Act
limitation-
will be applicable if the statute does not provide.
Lordship, that part also already, lordship, decided by the various high courts, lordship, even Supreme Court judgment I am relying, lordship.
Okay,
Supreme Court judgment. Although our high
but the
court
statute 23 itself provides for
provides for 90 days, lordship.
limitation of 90 days.
90 days, lordship, but perimeter provision is there in any other act also, lordship, where there is a express, lordship, exclusion of the limitation act, lordship, then it will not applicable as per the law laid down by the other high courts. Although
Every appeal under
Lordship,
this section
Lordship,
shall be
Lordship.
preferred within the period of 90
Lordship.
days from the
Lordship.
90 days from the date of this. So limitation period is prescribed by this statute.
prescribed by this statute, but there is no express bar, lordship, regarding non-application of the limitation act, lordship.
Okay. When,
Non-application, when there is a even, lordship, the for a moment, lordship, we assume that the appeal against the order of the single judge's, lordship, within a period of, lordship, 30 days, it should be preferred, lordship. There is a provisions of the Guwahati High Court rules, lordship, there is no express provisions regarding non-application of limitation act. Then also our high court can exercise the power regarding limitation part, lordship. So, lordship, our basic contention is that, lordship, the limitation act, lordship, is applicable here as because, lordship, there is no express bar, lordship, regarding the non-application of the limitation act, lordship. So my lord may kindly come to, lordship, in limitation act section 29, lordship, by the
Yes. it is there, it is there.
Oh,
Yes, yes.
if, lordship, I mean, I can
Section
read
29.
section 29, lordship. 29 2, lordship.
Yes, read it.
Lordship. Where any special or local law prescribed for any suit, appeals or application, a period of limitation defined from the period prescribed by the schedule, the provisions of section 3 shall apply as if such period where the period prescribed by the schedule and for the purpose of determining any period of limitation prescribed any suit, appeal or application by any special or local laws, the provisions contained in section 4 to 24 inclusive shall apply only in so far as to the extent to which they are not expressly excluded by such special or local laws. It is the statutory prescription that, lordship, it should be expressly excluded by that special law that the limitation act is not applicable. Then, lordship, it will not applicable in the case of the Railways Act. If, lordship, the Railways Tribunals is a special act,
No, just a minute.
Lordship. Again, I read, lordship, permit, lordship, the
Yes,
provision,
again, read again.
again, I read.
Read.
Where any special or local law prescribed for any suit, appeal or application, a period of limitation
What
defined.
has been prescribed is the
Lordship.
period of limitation.
Lordship, lordship.
So this order 29
And it also
subsection, no, section 29(2) speaks about period of limitation.
period of limitation, lordship.
Okay,
Period of limitation,
different from the period prescribed in the
lordship.
schedule.
the provisions of
Provision of
section
section
3
3
shall apply.
apply.
If such period where the period prescribed by the schedule and for the purpose of determining any period of limitation prescribed for any suit.
What is section 3?
Section 3 for limitation, lordship. Section 3,
Bar of limitation.
bar of limitation, lordship. Bar
Okay,
of limitation,
okay.
lordship.
That means the specials, the period of limitation prescribed in the specials
Lordship.
statute shall apply.
Lordship.
Thereafter,
Thereafter, lordship may kindly peruse.
if such a period
Lordship.
where the
If
period
is such period where a period prescribed by the schedule or for the purpose of determining any period of limitation prescribed for any suit, appeal or application by any special or local laws, the provision contained in section 4 to 24 inclusive, lordship.
shall apply only in so far as and to extend to which they are not expressly excluded by such special or local laws. If lordship the special law or local law expressly lordship the intent of the legislature is that lordship, the section 4 to 24 will be not applicable. That should be in expressly lordship in the statute books lordship. If it is not expressly lordship provided, then lordship the by operation of the law, the operation of the lordship, section 29(2) lordship, the limitation act will be applicable lordship. Here the Railways Act lordship, there is no
We are
express
concerned with section 5 of the limitation.
lordship.
So you are saying that as section 5 has not been expressly excluded,
Expressly
it will
excluded,
be applicable.
it will be applicable. Yeah, it was also law laid down by the various high courts lordship. Although our high court decided against us lordship, and that particular case was put before the honorable apex court also lordship, and honorable apex court says that status should be maintained as on today lordship. On the basis of that lordship, similar IA was also preferred before this court lordship, and honorable court views that lordship, it is pending till to the outcome of the SLP lordship. It is there.
Now, what is there before the Supreme Court? What matter?
Supreme Court lordship against the dismissal of the petitions filed under section 5 lordship. It was came to the honorable Supreme Court lordship. Honorable Supreme Court says that status quo as on today shall be maintained lordship.
In respect of those cases.
Those cases lordship, it is there lordship. And on the basis of that lordship, one IA was also preferred, that was argued by me lordship. And honorable court, our high court view is that lordship, it is pending till to the final disclosure. If lordship perus, then lordship can
No,
peruse.
which is the order of Supreme Court?
Lordship, I provide. It is detailed.
No, Mr. Gogoi.
Lordship,
Your submission is that in a similar case
lordship.
where the question of whether special statute would be applicable
Lordship.
or limitation act would be applicable
Lordship.
was raised,
Lordship.
where this court held that, what was held by this?
This court held that
Ordinate
lordship,
bench.
the limitation act is not applicable.
Not
Not
applicable.
applicable.
Then
And
the
against that order lordship, we have
preferred,
preferred
the
SLP before the honorable Supreme Court.
where is the order of
Lordship,
SLP?
I have placed it. And leave is granted and it was lordship posted for hearing lordship. And leave granted order is also here.
No, but it does not speak anything.
Lordship.
It
Exactly, my
It
lord.
does not speak anything about applicability of
Lord,
order.
that is lordship as and when leave
It
is granted.
will not help you in this.
Just I point out, lordship. Just I point out that similar case was before the honorable apex court. On the basis of that lordship, our high court has passed the order. That order I have recorded.
Okay, in these Supreme Court's orders which you have referred, only leave is granted,
Leave is granted and
status quo is
as
maintained.
of today shall be maintained lordship.
But court has not stated a single word on,
Exactly, my lord.
you will get your, I'm going slow, you will get your turn. So let me put queries.
Lordship.
So how it helps you?
Last time indicate lordship, on the basis of that order lordship, the honorable single judge coordinate bench has passed another order. That's why I am lordship referring this. That is before, that is before lordship. My lord Justice Bhaikum. Otherwise, I will place my case, just I am indicate, if shortcut, then it will suffice, then I will stop here, otherwise I will place my case lordship. Thus, I am indicate what coordinate bench has observed lordship.
No. On perusing these orders of Supreme Court,
Yes, sir.
it is difficult to understand what was before Supreme Court. What
It is
you
there,
take.
it is there.
Where?
Lordship, it is against the Sushil Kumar order, that orders I have lordship.
Which order?
I have lordship. Who is order against the SLP was preferred lordship? It is written, huh? Against this order lordship, the union has gone before the honorable apex court lordship.
And lordship, the one pages Honorable Supreme Court order that title pages it was reflected the MFA number and so on so lordship.
What is this? What is there in this case?
In same issues
What same issues?
regarding lordship, condonation of
Applicability,
lordship.
applicability of limitation.
Applicability of limitation act. It was negated by the Honorable, our High Court lordship. Against that, we have preferred the SLP before the Honorable Apex Court lordship. And leave was granted, and Honorable Court says that lordship status present today shall be maintained. lordship.
Now, what is this case? This is a big,
Lordship.
in this case, what has been held?
In this case, lordship, on the basis of the lordship, Jasiruddin case lordship.
Sushil Kumar case,
Lordship, Sushil
which you
Kumar
have,
says that on the basis of the earlier, by relying the earlier judgment passed by this court, Honorable Court held that lordship section 5 limitation
cannot be taken to
cannot be
court.
taken into consideration. lordship.
So that is the precedent available.
That is the, and against that lordship, we have preferred the SLP,
Supreme Court.
and that is the order of the SLP. lordship. And
So, Supreme Court has said nothing about applicability of.
that is what will be decided whether it is leave is granted. Then leave is granted, it will be for listing for hearing lordship.
No.
Lordship.
But as on date.
As on that, there is no decisions regarding applicability of the Section 5 Limitation Act
Yes.
from the Honorable Apex Court. But various High Court, even lordship, they are day before
But
yesterday.
our High Court says that it
Our High
is not,
Court says
not
that
applicable,
it is not applicable, but various High Court says that it is applicable lordship.
which will be binding on us.
Persuasive value is other High Courts, even lordship may, after it lordship satisfied, lordship may take a different view also lordship.
No, I cannot take different. If I take different view, I have to refer it to larger bench.
Larger bench also. That is why I will satisfy your lordship regarding everything at to Z lordship. That is
I
why.
need, I
And-
will have, I
and-
will have to have a long hearing.
And on the basis of that, my lord, Viking has also had similar issue, lordship. Almost that side also from the petitioner's counsel.
What she has,
She has stated
that-
after lordship the recording of the arguments advanced by our counsel. It was represented by me as well as the respondent counsel. After that, my lord has said that deferred to the disposal of the
civil appeal.
lordship. Deferred the disposal. If lordship, and otherwise I will place my case and I will try to satisfy lordship. If lordship satisfied, then lordship may refer to a larger bench. Even